हेलो सर, वाइट पर वीडियो क्लियर दिया। हेलो।
Monday. Huh? What is the urgency? Monday. Or everything on Monday. Yes.
The Lordships kindly.
Yes.
Milord, serial number 24, Milord.
Point.
Serial number 24, Milord. Milord, that this matter will posted after the
There is a bunch, right? No. This is
Not connected. Dealing. Yeah,
that's all right. Yes. Madam, please write. K. Joseph Lund, counsel for the petitioner. Let this writ petition be de-linked with WP number. This is PC WP number 23258/21 and be listed separately for hearing on which day you want after ensuing summer vacation. That's why we have said please ask.
Last time I asked to consent answer.
Why they don't do it?
Lordships kindly.
Yes.
Serial number 24, my lords. Lord, in this case, my name has not been shown. BL because there is a judicial order, Lord.
Who is your appearing for appellant?
Appellants, my Lord. BL Nandakumar, my name has not been
is not there. Counsel for respondent is not there. Counsel for respondent. We will.
I have informed, my Lord. I have already informed, my Lord.
What informed?
I'm just seeking adjournment because
we'll adjourn it when it is called. You need not appear. We'll adjourn it.
Much obliged.
Anil Kumar, yes.
Mr. 24. Yes. Learned has filed a memo. Leave of this withdraw the memo taken on record dismissed as written.
Atu, Sri Vishnu Dutya Manjana.
Yes. Yes.
Last occasion, I have put an application for retaining in command. And I responded to the wife. She wants to challenge her husband. Last week it was displayed and I requested your last to send it directly. Appellant may consider our request and take back. She presented before the court.
So we will pass it over. Let him come.
Please.
So that something effective can be done.
Please.
Ask her to wait. Just wait. Yes.
I request for total.
Whenever it comes up, I really don't know. Yes.
To ask the appellant counsel to be present at 2:30.
Three, Madhukar Nadi, Rohit Vijay, Nitya.
Where is?
It was executed on 28/3/22, my lord. That was received by the Commissioner of Police Office on
23.
28/3, my lord. Bailable warrant was issued. That the Commissioner of Police issued the bailable warrant on 4th, my lord. 4th was the hearing date for this article. Only on the evening they received the bailable warrant. And on 4th, the Honorable Court was pleased to reissue the NBW, which they received it yesterday evening, my lord. On account of paucity of time, they could not execute it.
Worship, and for the respondent number 3. The respondent number 3 is present before the honorable court.
On the last 3 occasions, you were not present.
We have to, for you, he has to come here, right? What is this? No, we will send him behind bars. Right now, we will ask him to take him away.
Lordship, the watch list was not getting communicated. So
Not company. What is this? We have been issuing, despite service of notice, you have not appeared. You have run away with the custody of the child. What is this?
Lordship, there is a family court case going on.
The mother doesn't know whether the child is alive or not. What is this?
Lordship, they are referring to the family court in JWC matter. There was a mediation also. They hide all the facts before this court, your Lordship.
Yes, tell us. Yes, Mr. Yes, go ahead. What is there? We will hear it. Yes. Now, why?
Case pending.
No, case pending. Why what is the age? What is the date of marriage, Mr.? Even 3. And when was? What is the name of date of birth of daughter?
2/3/2013.
2/3/2013. 30. What is the name of the daughter? Adya. And son? 4770. Amog. So the petition is with regard to custody of this child. The CBS corpus. What? So where were you? What is your client doing, Mr.? Software engineer.
What is he doing? No, what is he?
Petitioner. What is the educational qualification? What is she doing? Private company? HRD department where?
What is the name of the company?
What? So where the parties were residing, where was the matrimonial home? Hey, are they residing together? No. Bangalore. 2121. So what happened? The husband went away. Where is the respondent residing? Bangalore itself. So separately, right? Separately. Separately. No, what has happened? So husband has taken away the child. What? When? Huh?
In January 2021. And the petition was filed before the period.
2nd January 21. The husband took away the child without informing. You should go. I mean. Uh, uh. All right. You don't seek instructions from your clients, right? She is arguing the case. Huh? This is unfortunate. Unfortunate. Not feeling well. Fine. Then you should take rest. We will ask her only. Yes, Mr. What is
Lordship, in the month of January 2021.
No, first explain the conduct of taking away the child
Lordship,
without informing the petitioner.
Lordship, it is completely lie and false. We filed a JWC.
No. So you want to say that the mother has deserted the child, and therefore you are taking care, right? This is what is the stand. So don't act smart, and don't forget that so Commissioner of Police is still in the court. He will take away your client.
Lordship,
Don't.
I humbly pray that this JWC case, which is pending because of
So pending.
litigation proceeding. In litigation proceeding also, she said she was not ready to accept any conditions.
So you who has filed this JNWC case?
And she has never filed any visitation.
Pending, Mr. So the answer is simple. Pending decision of the JNWC, the child with the mother, you will have the rights of visitation if you want to visit the child whenever you want.
Lordship, they have not even prepared any application for visitation in the family court. The mediation.
So this is habeas corpus.
Lordship,
This boy cannot be kept away from the mother. That's simple. What is his age? 4 years. Okay.
Which may be asked to the boy and mom.
No.
Lordship.
Boy is a minor. He can't. This thing, his welfare lies in staying with the mother. And you understand, Mister. Please understand. We are dealing with a human problem, right? It is not a question of winning or losing a case. Both of you means parties have given birth to a child, and it is your responsibility to see that the child develops as a proper human being. For his overall development, he needs the love and care of the mother as well as the guidance of the father. But you can't make him like this thing, a trophy in the battle to be won, that he will run away with the child and he will not appear. This conduct is highly this thing.
First of all, apologies for all.
No, not apologize. There's no question of apology.
I just wanted to.
No, you were, 2 bailable warrants have been issued. You have not appeared. This is what. And it takes Commissioner of Police to come to this court for you only. He has left his office. He has, public must be this thing waiting for him in his office. He has so many works to attend. What is this? For you only. So you have to hand over. There is no this thing.
You and our knowledge, you Lordship.
No, we are directing the custody. No knowledge is good. Fine.
Somebody pray that just look into the welfare of the child.
Welfare, we know what is the welfare.
Lordship,
We know, and Supreme Court says also what is the welfare. We have recently, yesterday only, we have decided. It meant 2-3 judgments which have been upheld by the Supreme Court. So we know what is the law. You have not brought a single book, nothing. You have just walked in to this thing. Tell us. We are not in a casual conversation. This is an argument going on. We are telling the law is that the child who is a minor, aged about 4 years, cannot be kept away from the mother. That is what Supreme Court says.
you can give any visitation rights, your Lordship.
The visitation right, we are telling you. Visitation right, please ask him when he would like to visit. We will fix.
May I ask me?
Please ask. Please ask. When will he like to go? What time?
There was some allotment in that court. That's it.
In the last mediation, we proposed the custody to be with mother with the weekly 2 days of visitation rights.
Huh? 2 days. When? Send. What time?
Can we enter the morning to 8 in the evening?
This is visitation right means what? I mean, visitation right would be for some hours, right? 3, 4 hours, 5 hours. Whatever time you tell.
2 to 6 o'clock.
2 to 6. Fine. Good. Nothing. Saturday, Sunday, he said. Saturday, Sunday is saying. They have agreed. I mean, we are passing and we are happy that it is being passed on with the consent of the parties. You fight it out, Mr. Your custodian, guardian, and what's proceeding. You fight it out, whosoever the court decides, right? But the child should not be put to any emotional strain. And Mr. Ask your client to allow access to him. Yes, he will come and pick up the child from there. He may spend time there, or he may take away the child and then will again bring him at 6 p.m. Fine. Mark the presence of parties along with this, with petitioner and so and so learned counsel with the petitioner, so and so learned counsel with respondent. In compliance of the order, respondent number 3. Respondent number 3. In compliance of the order dated 11/4/2021, the Commissioner of Police Mysore, what's his name? Is present before this court. Present before this court. This petition has been filed seeking a writ of habeas corpus, directing the respondents 1 and 2 to take necessary action to produce respondent number 3, namely the husband along with minor boy Amoga, and to Amoga before this court. And to that's all. Paragraph. When the parties are present before this court has interacted with the parties. The parties have therefore agreed to resolve the dispute amicably, subject to following terms and conditions. Number 1, the respondent the husband has handed over the custody of the minor child, namely Amog, to minor son, namely Amog, to the petitioner. The minor number 2, the son of the parties, son of the petitioner and respondent number 3, namely Amog, shall stay in Bangalore with petitioner number 3. Petitioner number 3, number 3, the petitioner shall have the respondent number 3, namely the husband shall have the visitation right, which can be exercised by respondent number 3 on every Saturday and Sunday between 2 p.m. to 6 p.m. the afternoon. Full stop. It would also be open to respondent number 3 to take out the child and to bring him back and hand over the custody to the petitioner on or before 6 p.m. Paragraph. The aforesaid, needless to state that the aforesaid interim arrangement shall be subject to final outcome of the proceeding under the Guardian and Wards Act, which has been initiated by respondent number 3. Accordingly, the petition is disposed. Why? He has to give the custody. He has taken it back. No, you have to give it back. So from Monday to Friday, he is in the exclusive.
Only afternoons. Saturday and Sunday, only afternoons.
2 to 6, not the whole day. Only for 4 hours on Saturday and Sunday. See, you should understand the child needs both of them. It's not a question of fighting. That Guardian and Wards Act will decide who is. No, don't. Not necessary. Not necessary to make any allegation.
Two, Kiran TV.
I appear for the appellant, Your Lordship. I praise for a 2 weeks time, Your Lordship. I filed a NOC Wakalam for compliance of the office objection, Your Lordship.
Number 5, Sri Sanjay Bia.
This matter, 2 weeks' time may be granted, my lord, for complying.
Venkatesh Reddy.
What happened in mediation center?
Mediation, there are the magistrate, there are, and they have a brief for the separation.
Learned counsel, this, where is the report? This appeal, party presents this appeal under section 39 of the Special Marriage Act has been filed against the judgment dated 8th of July.
Report is not received.
Yes.
Some file in the joint memo.
So you file a joint memo. What is report is not there. What is it? What they have compromised? You can.
Wait for resolution of the marriage. It was organized.
You give us this thing memo, right? You file a memo, we will dispose it of. Right. This appeal has been filed against judgment dated 8th of July 2021, passed by the family court, by which the petition filed by the respondent seeking dissolution of the marriage under section 22 of the Special Marriage Act has been allowed. Let's say the parties are present along with their counsel in the beginning itself. Parties present along with their counsel, write their name with so and so, so and so. This petition has been filed. It is stated before us that the parties have amicably resolved the dispute between them and have memo has also been filed before us, which has been duly signed by the parties. The counsel for the parties also state that the dispute between the parties have been amicably resolved on the following terms and conditions. Number 1, the marriage performed between the parties 6/10/2016 is dissolved by a decree of divorce. No. In the beginning, what we have written is this petition will be filed against judgment dated so and so, by which petition filed by the respondent. The section 22 of the Special Marriage Act has been allowed, and the appellant wife is directed to join the matrimonial. That's every following terms and conditions. Number 1, marriage between the parties so and so performed is dissolved under section 27 of the dissolved. That's all. Dissolved by decree of divorce. Number 2, what is it? Permanent alimony. So anything. So then the only thing is that you agree for dissolution, right?
All allegations made.
The parties withdraw all the allegations made against each other. The appellant, further undertakes not to claim any matrimony from the respondent. Paragraph. In view of the amicable settlement of the dispute, the judgment and decree dated 8th of July 2021, passed in MC number 1 of 221 and MC number 2 of 21, is accordingly modified. In the result, appeal is disposed of in terms of compromise arrived at between the parties. This appeal is filed against MC number 1 of 21 and 2 of 21. Which appeal against 2, sir? Acha, appeal is filed against. You have written MC number 2. No, it's a 2. MC number 2 of 20. So take this memo and get their signatures also. You also sign, both of you.
Yes. Number 7, the Arjun PK.
Memo has been filed. Come on report in the result appeal is dismissed. Petition is dismissed as withdrawn. His objections on IA, what corrections?
All corrections are done.
What?
For paragraph 2,
How long?
well, paragraph 2 of
Paragraph.
page number 4 below next.
Para, page 4.
Commissioner Central Tax,
Where?
not follow.
With commission. Taluk.
Not follow.
Yes.
And not the audit has to be. Commissioner Central Tax, Bangalore North.
Audit.
Here, top.
Here also. So 2 places it has. All right. Yes. All right. Heard learned counsel for the parties. After hearing learned counsel for the parties, it is directed that in the order dated 31st March 2022, passed in WP number 22485/2021, in paragraph 2 and 3, the instead of paragraph 2, 3,
Operative portion.
3,
Operative portion also.
2, 3 and 4, the word Commissioner Central Tax within bracket audit Bangalore North Taluk shall be read as Commissioner Central Tax Bangalore North.
Principal Commissioner
Shall be read as Principal Commissioner
Central Tax Bangalore North.
Principal Commissioner Central Tax Bangalore North. Right. This order shall be read in conjunction with the order dated 31st March 2022. All right. So, and then the line before this order shall be read in conjunction. The time for making an additional submission before the Principal Commissioner, so and so whatever you have written, Principal Commissioner Central Tax Bangalore North is extended up to 21st April 2020. This order shall be read in so and so. Accordingly, IA is disposed of.
Name may be shown, Milord.
IA 1 of 22.
My name may be shown.
Oh, name, yes. Yes. They do it normally. Yes.
You have given a standing instruction.
Standing instructions, my brother tells.
Pledge notes.
Yes.
9. Government education.
Take notice. What dispute between husband and wife? Oh, you are what? A husband has filed habeas corpus. Child, where is the custody of mother? Or on the question of admission notice on behalf of 1 and 2 is accepted. 1, 2 and 1, 2, 4 and 5 is accepted by Srimati Mani, learned additional government advocate. Office is directed to reflect her name. How much time, madam, you want? The praise warrant is granted 2 weeks time to enable her to seek instructions. Issue emergent notice to respond number 3. This objection first undertakes to comply within 3 days. Please do it. 3 days means 3 working days. Yes.
Number 10.
Comply, Mr. Girish P. Baldare, learned counsel for the applicant subjects. That office objections have been complied with today. And the objections with regard to payment of deficit court fee shall be complied with within. So what you are saying that deficit?
Deficit he has paid today. Deficit he has paid today.
So then simply say no that you are learned counsel for the applicant subjects that office objections have been complied with today. Offer force is sufficient. Office objections ignored, admitted for hearing. Issue notice record.
11, Mohan DK.
For petitioner, my lord. My lord, in this case, the petitioner, the respondent, the petitioner had filed a petition for dissolution of marriage before the trial court, my lord. It was only a petition for dissolution of the marriage. In the said petition, my lord, the court, along with dissolving the marriage, also directed the petitioner to pay maintenance to the second and third respondent herein, my lord. The office has raised the objection, my lord, that second and third parties were not the party before the trial court. The office is this. Sorry, my lord.
What is your explanation? 2 and 3. Why have you?
The second and third party were not the party before the trial court, my lord, because it was a pure petition for dissolution of marriage. In the
Who are respondents 2 and 3?
They are my children, my lord. But I had filed.
Then why are you making them as a party?
No, my lord. What had happened is, my lord,
the court has asked you to pay the maintenance. You need not make them as a party here.
Because they will be affected, my lord. That is the reason which I had filed the.
Not necessarily.
No, not necessarily.
Because no maintenance has been granted to
so
the.
You make an application, Mr. Whatever it takes to comply with office objection. We are not accepting. After hearing learned counsel for the appellant, submission made by learned counsel for the appellant that the children of the parties, appellant and respondent number 1 have been implemented in this appeal, even though they were not parties in the proceeding before the family court, on the ground that that they would be affected by an order which may be passed in this appeal, does not deserve acceptance. The same is the office objection is upheld. Let objection be complied.
My lord, I would delete their names, my lord. But in the meantime, my lord, the trial court order may be partly stayed, my lord.
You comply the office objection.
My lord, may I request for a date, my lord? I would do it on Monday.
Do it, then ask for a date.
My lord, I would request for a specific 23rd, my lord. By then, I would correct, my lord.
No. First do it, then make a mention memo. Yes. Move a mention memo.
Oblige, my lord.
In an IAS number 12, CH Suresh Desai, Mohit Kumar.
On IA 1 of 17. After hearing learned counsel for the parties taking sufficient cause delay, IA is allowed. What is it, Mr.? What has been done? Husband petition allowed, admitted for hearing record. That's what we are doing.
13, CRS Ravi.
On IA 1 of 2019, taking into account the fact that the appeal is pending before this court since 2017 and taking into account the involved between the parties, IA is allowed. Let the appeal be listed for final hearing on 31st May. Oh, why?
Retirement benefits.
This is family court early hearing. You don't want early hearing, right? We have allowed it. It has become, you are withdrawing. Why early? How can early hearing become infructuous? The appeal is pending. How can appeal application for early hearing? The application for early hearing is for appeal. Hey, Mr. Natraj, please see what is the early hearing application. Early hearing is of the appeal. Appeal.
Reasons assigned there.
But we are coming across a first counsel who is even opposing the prayer for early hearing. What is the, you don't want this appeal to be decided? Huh? So we have fixed it. We have fixed it for 31st May, right? For hearing. You can't oppose it. I mean, if you are aggrieved by it, we will say that you are opposing the prayer for early hearing. So, but we will fix it if you want that order. It is our discretion, right? This is 2017, 5 years have passed. Your client is not in a hurry. Are you in some better cases? Not oppose, don't oppose prayer for early hearing. Hearing. Same order. Allowed. Madam, 2nd June. 2nd June 2020. Same order.
15, Sri Chetan Bisi, Sri N. Srinivas.
Allowed.
In this, my lord, I appear for appellant, my lord. I was appearing. I
What's
have
your
given
name?
NOC to the client, my lord.
And then again, somebody is saying that she has also given NOC. So who is appearing?
No, BC, Chetan BC. Myself,
You
I
are
have given
appearing.
NOC, my lord.
Mr. Chetan BC submits that he has given NOC. Wakalat office is there so directed to delete his name and to reflect the name of as counsel for the applicant. IA 1 of 18 is taken up. Reason assigned duly. Delay of 81 is condoned. IA is allowed. What is there? You are for respondent. So we thought that you are appearing with her.
No, my lord, I was asking whenever would it be posted for the final year?
Final year. Yes, yes. Whenever you want, any date after vacation. 6th June.
Records have to be called for.
Records.
Records be called.
Records have been called. Called. To be called. Records be. List for appeal is admitted for hearing. Office is directed to secure records of the family court. List on 6th June 2020. Yes. In that case. Condoned IA is allowed. Appeal is admitted for hearing record.
Number 17, government advocate.
Yes. What is it? Who is appearing for the applicant? None.
Number 18, Sanjeev B. PN Manmohan.
I appear for the petitioner, my lord. 18, my lord. Weeks time may be given, my lord.
But he himself is praying for time. Mr. Sanjeev.
I comply with the office objection.
What's your name, madam? The counsel has entered appearance on KV8. Please supply a copy.
I'll do
Learned counsel for respondent on KV8. Learned counsel for the petitioner praise warrant is granted a week's time to enable him to comply with office objections as well as to serve a copy of the memo of appeal along with annexure. Learned counsel for respondent. Who has entered appearance on KV8. That's all. Respondent, that's all.
Number 19, government advocate, CBS Nagaraj.
Yes.
We will serve a copy of the interim order passed by the Honorable Apex Court.
You don't want to file. She says. Then.
To file necessary application for vacating. File necessary application for vacating. Already stay is granted.
That is why my kindly see the order dated 22/12/2021. I undertake to precipitate, not to precipitate the contempt proceeding. They dated 22/12/2021.
On 23/2/22, the appeal has been admitted and interim order has been granted as prayed for.
All right. Fine, fine. So you don't want to file any objections, right? That's what we are telling you. That's what she said in the beginning. Choice is yours.
Is it possible for hearing? Interim order to continue?
Yes. Learned counsel respondent gratefulness granted. How much time? Weeks time to enable him to file objections to IA 2 of 21. 2 of 21. Interim order granted on earlier occasion shall continue till next state of hearing.
Number 20, release and segregate.
IA 1 of 22 is dismissed as not pressed. Vote on the what husband's appeal dismissed? What petition? You are seeking dissolution of marriage?
Husband is allowed.
Huh?
Husband's petition is allowed.
Allowed. Vote on the question of admission as well as IA 1 2 of 22. Appeal is admitted for hearing. Office is directed to secure records of the family court. In the meanwhile, it is directed that operation of the impugned judgment and decree insofar as it pertains to dissolution of marriage between the parties shall remain stable.
Number 21, after the year.
After IA 1 of 22 is heard on the question of admission. What happened, madam? Dismissed. What state? Dismissed. Counter claim. What? So you are opposing that also? So you are aggrieved only by this lifetime. Heard. Fine, fine. All right, fine. But on the question of admission, learned counsel for the appellant submits that the appellant is only aggrieved. Appellant is that this appeal has been filed. Learned counsel for the appellant submits that this appeal has been filed against impugned judgment dated 29th November 2021. Only to the extent it directs payment of amount of maintenance of rupees.
No. Your appeal is against the dismissal of your petition as well as against maintenance.
Then you are unable to even tell us, madam, what is we have to look for it. And you are here to assist, please. You could simply tell that my petition seeking dissolution of marriage has been dismissed. I have filed this appeal against this that judgment and decree. You are telling us that only maintenance. We asked you that other. You said yes. Really heard on the question of admission as well as IA. What state? No. Appeal is admitted for hearing. Record issue notice of IA. 1 of 2 of 22 to respond. Oh, yeah, that is dismissed as.
Number 22, Ramesh and government advocate.
We have some difficulties today. Let it come next week.
We also don't have any difficulty. Go ahead. Huh?
Sir, nullification matter long delay of over 30 years.
Oh.
I don't come and raise my land fence seeking a time, but not beyond vacation. What's my habit anymore?
Mr. Naik, why don't you prepare some date-wise event? Done.
Have it already.
All right. Where is? So yes, what do you want? You are ready. This is being heard. Yes, you are ready. So you said it's all right. Is that memo? Just 1 minute, 1 minute. We have to. You are not telling us facts. We will have to ascertain, right? Who will write the judgment? Within 5 minutes. Where is what is this? Consideration doesn't mean.
Formation of regional housing. The first team member, the then CID member of Mysore. Number 4, 1981, has issued a preliminary lands formation of many land was also notified. My neighboring land, it's about piece of land. 202 was 202 was 202 was 3 is my land, and 202 was 2. It's a bit of interest of the land. The current report is 202 was 3. It's also under the availability. It's an admitted fact. It's not a dispute. And on 1984, the final declaration was made by the CH-2. Thereby, there was a mistake occurring there. Instead of showing my surveillance on 202 was 3, it was shown as 20 was 3. Thereafter, my life, there was no notice about the side mistake. There was no information to me about the side mistake occurred in the final declaration. Thereafter, in 1986, the Aragon notification came to be issued. And then it was corrected as 202. 2 years from the final declaration. From the preliminary notification to the Aragon notification, there is a gap of 6 years. It is not provided under. It is not provided under the Land Acquisition Act or under the other development. Yeah, Telecast notification came to be issued in 1986. Thereafter, also method that was also kept in draft. No information to me. The Apex Court has said that after issue of award notice, the entire proceedings will start for the land acquisition. That was compliance of Section 5 of the Land Acquisition Act or the CIT Act which has been taken out by the state law, that's Karnataka Urban and Housing Development Authority Act. So that 27 involved a substantial scheme has to be implemented. Last year, this bench is read. Section 6 of 11 is exempted from the Land Acquisition Act, which is not applicable to the state law. Other formalities like issuance of notice, calling for inquiry, calling for original documents, taking the possession, all these things has to be followed in accordance with the Land Acquisition Act, Section 5, 8, and all these things. Even there is an involved, even if the problem is laid out in the AAB Act, and 15 and 17, 18, and 20. What was the first issue? No inquiry of land acquisition. The document was very please get you to the first time I learned after that of 30 years, when the repetition was pending before this honorable court. Even after the repetition, 2015 I applied. 2015, the first award notice has been issued. My lord, he called for an objection, he called for my documents, he called for an inquiry during 2020. Then 30 years delayed on the part of the state. My lord, it was well aware that the article of this court and this court has guideline. And there is a fraud. Then there is a continuous cause of action. Then the fact shocking to the judicial conscience of the court. Delay cannot be raised in the constitution. Let us proceed. Today. Just read a headline, please. Article 300 is provided by
Consideration.
state by authority of legal established by law. Obligation to pay compensation, though not explicitly included in Article 300A, can be incurred in any case at time of disposition of a claim in 1867.
Right, so we'll hear it, Mr. Nayak, after vacation. It requires consideration. Appeal is admitted for hearing. Let the same be listed. Oh, no part. Here, admitted for hearing. Let the same be listed after entering summer vacation.
Is there any interest?
Interim order. All right, we are not saying anything.
For 23, Prabhakar Indi, 1,000 rupees, yes, Nagaraj.
Objection on IA. After vacation, you list cases only under the heading of admission and final hearing. After I don't understand what preliminary hearing means. They want to argue everything finally. Preliminary hearing means appeal should be. Why it should be heard, Mr. Your case finally, please tell us. Huh? We are just asking you about the system, right? Where it is for orders on admission, it should have come up. It is listed for preliminary hearing. So what you are trying to do is to argue a case finally, right? Why 21 appeal should be heard finally and 2011 matter should be kept in final hearing list? That's the question. We have said that appeal should be listed for orders on admission, so it has not come up. We will hear it on admission in compliance of the order dated 19/11/2021. Let the appeal be listed for orders on admission. Contempt. All right, 19th April. If it's urgent, when is the contempt listed?
Order is to pass regularization. Benefit status quo. It's working. You are in service.
Not even paid the salary.
No, no, paid salary is different, but you have not been removed.
Sir, not even allowed to work. That you are not removed as required under the provision of Karnataka Daily Supplies and Repair Act.
Now the government has passed an endorsement. It is not anything. There is no sanction. That has been challenged, which is before the single judge now.
You comply.
Now, this also has to be
All right.
had very single judgment because of the government's endorsement. Otherwise, it will be single judge. But the press certification in the light of the endorsement issued by the government. I am not the authority. I am not paying challenge enforcing authority. Then the direction.
There is a two part of the order, page 33, 31 and 32.
No, but what is the order, Mr. Directed to consider the representation? So you don't even want to consider. Why?
2007
So you consider what is there.
But now I have produced the memo under the order passed by the government. Endorsement issued by the government.
But what is there appears to be nothing wrong with the order.
We have
Not to claim until regularly, not to dispense with services, not to replace.
There's no education qualification. No sanction.
You have to consider the court is not saying direct you regularize his services. Consideration you have to, if he makes a claim, you have to consider it and say that he is not fit for regularization. What?
That has been challenged because we are seeing it now in the restriction number 22410 of 20.
My lord, there is a two part.
1 minute, one by one.
Then what survives here?
What survives? And what are you contesting? You pass an order, what is there? It has already been rejected, again it is rejected. What's there? Who prevents you? Give it tomorrow to him.
Take it back to the service. I am not the appointed authority. I am not the silent.
No, you have already rejected. No, is a representation you have rejected. Then where is the question of taking him? Yes. Where is the question of taking him back then?
They have said there is no sanction. Does not conform to the criteria placed by the government. And it is that was not the
Report shall be
observation circus.
The second part.
It could be only in the consideration.
But he says it has not been taken. If this, then he feels then that he can battle that they will have. We don't know why you have come here and filed an appeal.
Now, filing this, government has considered that representation and said to 2007 itself it has been considered, but second time it has been considered.
It's directed to consider the representation date 31st March 20. Where is that? So then what survives, Mr. in this petition? Just a minute. When this representation has been decided?
6/11/21.
21. 57. Fine. 6/11/21. Considered, right?
That has been challenged in petition number 22-410-21.
22-410
of 2021.
All right.
It's pending.
Fine. So therefore nothing. And who is respond number 5? Town Panchayat.
Respond number 5 is the appellant here.
So continue the petitioner. What is 6/11/21 is what? Memo. Page. Which page?
Page 157 in the memo.
Really difficult. You file a petition and then keep on filing memos. This one. What has they said? 1 minute. 1 minute. What they've said.
Regularization is not possible.
And
They
what about
rejected.
his reinstatement?
Regularization is not possible. It's nothing.
This thing. This claim up to 6/11/21 has to be considered. 15th April 21.
During the pendency of the writ petition, you had paid him salary. Till what date? After thereafter, he has not.
Hey, August what?
August 2020.
Digital system. Unpaid accounting system directly paid to the employees. Those who are not qualified will not be paid.
It is his case that after August he is not taken to. That is his case. In August they have paid. After August they have not taken into case. That is his case.
But you will, you have distanced with his services, you will employ in his place somebody else on a contract daily wage basis again as a tractor driver.
That all solid waste management has to be outsourced. So outsourcing by calling for tenders. The city is roll up the larger state so that manpower is not required now because they are done by the contract.
Government has said that he was not appointed as against the sanction court. It was only a temporary appointment.
What is the qualification of the court?
He has got fixed standard only. He himself has produced documents saying that he is fixed standard. Yes, that is fixed standard. On that count also he is not taking. And on Paris Code 2006, where the order to Supreme Court came, he was not eligible. He was not completed 10 years. There was no sanction court at all as of that. Appointed by President of the Panchayat.
Service is taking for dumping the
No, then if you are working, then it's fine. You have to your claim for regularization has been rejected. You have filed a writ petition.
There is a two part of the order.
One
is
continue. You told no. You told that you are continuing.
Continued whether he is allowed to. He is not even paid the salary from.
That is not the issue. That is you are working, right?
Yes, madam.
You are working.
I have produced the memo stating that the service is taking 6 days.
So you are in service, right?
Yes,
if you are not getting the salary, please raise a grievance. This is not the. This is their appeal.
Their appeal.
So we will have to. We will have. Even if we dismiss it, you don't get salary. Therefore, you will have to in the writ petition where you have challenged the order dated 6/11/21, you will have to claim the relief of salary that despite being this thing you are not, though you are working, you are not being paid salary. Make a prayer there in that petition. Right? That even if we dismiss their appeal, what do you get?
If they dismiss it, then I will pursue it. Because he responded directly to continue.
No, see the appeal. Nothing survives, strictly speaking, for adjudication in appeal for two reasons. First is that they have already considered your claim for regularization and your representation has been rejected by an order dated 6/11/21. You have challenged that order in the writ petition. So that writ court will decide whether or not you are entitled to be regularized. Second direction is that you should be taken back in employment. You are telling us that you are continuing in employment. End of the matter. That's what. Do seek the relief of this thing in that writ petition, salary, not contempt. No, no liberty. It's their appeal. It's there. We are dismissing the appeal. You do whatever you want. Yes. Nobody prevents you. Yes, this intra-court appeal has been filed against order dated 15th of April 2021 passed by learned single judge, by which a writ petition preferred by respondent number 1 has been disposed of with the direction to the state government to consider the representation has been disposed of with following directions. Number 1, the state government is directed to consider the representation dated 31/1/2020 of respondent number 1 for regularization in the light of observation made in the order within a period of 3 months. Secondly, town panchayat Peri Patna town panchayat, namely the appellant, has been directed to continue the services of respondent number 1 as tractor driver on temporary stroke daily wage basis with liberty to terminate or dispense services of the respondent number 1 in accordance with law and not to replace a temporary employee by another temporary employee. Paragraph. Learned counsel admittedly in compliance of the first direction issued by the learned single judge, the state government by an order dated 6/11/2021 has rejected the claim of the respondent number 1 for regularization. It is also not in dispute that opposite order is subject matter of challenge at the instance of respondent number 1 in WP number 22410/21. Paragraph. It is asserted by counsel for respondent number 1 that though respondent number 1 is performing the duties of the post of tractor driver, yet the salary is not being paid to him since after August 20. Full stop. Therefore, paragraph for the aforementioned full stop. Therefore, the direction number 2 issued by the learned single judge has also seems to have been complied with in view of submission made by learned counsel for respondent number 1 himself. Needless to state that in case respondent number 1 is not being paid salary, it will be open for him to raise the grievance with regard to non-payment of salary before an appropriate forum. Accordingly, the appeal is disposed of. Whatever. We have not said he is saying that he is working. That's why he is working. Yeah, so then he is saying that working, then you return, no? On the other hand, learned counsel for the appellant has disputed the aforesaid fact. So you say, be that as it may, it would be open to, in case the respondent number 1 is still serving as a tractor driver, it will be open for an appropriate appeal is this. Adjournment has been again appears.
That I am for the appellant's
He told us that he has already spoken to you and you have consented for adjournment beyond vacation.
Not beyond vacation. You can mention.
Yes. Put that no, we didn't adjourn. Otherwise, you would have been. He said that.
He has informed me. But
After vacation. When do you want this?
After vacation, my lord, any day after vacation, my lord.
You got it. Why we don't adjourn behind the back of the council? The senior council is saying that it should be, he has agreed to adjournment, but not beyond vacation. And supposing if at 10:30, if he would have adjourned, he would have been taken for a ride. He's not agreeing. He said that I agreed for next week.
Lord, I'm sorry, my lord.
That's why we don't do it, mister.
I'm going out of station next week.
That's why we don't adjourn, and you feel bad about it, but this is the reason. See, he's opposing. He's saying that next week, Wednesday.
Lord, immediately after vacation, you can post because I'll not be in station next week, Lord.
You are not in station even today also. Huh? Where you are appearing? We don't know whether Bangalore or anywhere, Chennai, whatever.
Lord,
you can be out of station.
Let it be posted immediately after vacation.
What is the urgency? Or after vacation. Then what? There's no urgency then. Even otherwise preliminary hearing. Place to mark the presence, learned counsel for the appellant, place for adjournment. List after immediately after ensuing summary.
Much less. Highly obliged.
Yes.
Keeping in account the increase in cost and in account in accordance with the bipartisan.
Reach paragraph 5, 6, and 7.
Yes.
Read it first. Why it has been dismissed, then you are straightway jumping to the merits. But you should know why it has been dismissed. That's why we are asking you to read.
It is not known who are the members of the particular association. What are the dates of their entry into service and their retirement? What is the pension? And as to whether all of the members of the association are retired between 118 to 31/10/87. It is only certain representations that are given in terms of the next receipt of which facts can be gathered. But even here, the dates of retirement of any of the employees of the association is not forthcoming. Representation also is given by the petitioner during seeking application of pension. As this, with the aforesaid all details about who are the affected persons, making new all statements that pension needs to be updated to giving sketchy details cannot result in a manual being issued. We need to consider that. As that regulations come about on 29/1995, it is presumed that the members of the association all opted for pension and they are seeking updation of pension. The regulation of the appendix which restricts updation of pension only to employees between 1/1/1986 to 31/10/1987 is not called into question. Therefore, the petitioner has not made up any right whatsoever in law. It will direct respondents to consider the representations as even for issues of the writ in the nature of handling. The demonstration of the right of the petitioner is granted for none, and then a corresponding obligation on the part of the respondent to perform.
You find a representation giving particulars. If that fails to evoke any response, file a writ petition. That liberty we will grant you. But are you disputing this facts that there are no dates and this thing? Who are the members? Nothing.
One submission in this regard. The key before the was that more than about 25,000 pensioners in the association were entitled to this scheme, all of whom are retired on different dates. Now, if the only basis on which the rate was dismissed was not punishing of these technicalities, it could have been done at the time of the property.
Technicalities means what technicalities? You should show to the court prima facie that the persons who have come before the court are entitled. What? This is not technicality. It's a substantive. You are claiming a substantive right, and before issue of writ of mandamus, the court must be prima facie satisfied that a case for consideration is made out. What? You are not this thing. For same reason, we will dismiss your appeal. Why? Don't argue on merits. Or we gave you that another option which is better, that you file fresh representations giving particulars. If the representations fail to evoke any response, you will be at liberty to take recourse to such remedy as may be available to you in law. With that liberty, we will dispose of this appeal.
Liberty by leave with petition. He says he wants a liberty to file writ petition if it is not considered.
No liberty to file. We will say you are there to advise your clients what to do. But we are inclined to, we are telling you that this thing we will uphold the order for the reasons. That's why you are arguing substantively as if without reading this, you have read it. What is it? Why your petition has been dismissed? If you want to argue, we will dismiss it on same grounds. No ground to interfere. That's what we told you, right? So we told you, I mean, though we are not supposed to tell you, but we told you that it's better that you withdraw. If you insist, we will pass an order on merits. This is there's no question of suggestion. This is it's very difficult to even to tell you orally, right? You will carry it to your clients also. Court suggested. We are not suggesting. We will dismiss your. That's better. Fine. This intra-court appeal has been filed. This order dated. You should be. I mean, we are being fair to you. I mean, what is this? Otherwise, we don't want this impression to be conveyed that we have suggested nothing. Our job is to adjudicate. We are dismissing your appeal. This intra-court appeal has been filed against order dated 26th March 2021, passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant is a vice president of Canara Bank Retired Officers Association who had filed a writ petition seeking a writ of mandamus directing respondent number 2 and 3 to update basic pension periodically as mandated under regulation 35 within bracket 1 and 56 of Canara Bank within bracket employees bracket close pension regulations 1995. Full stop. The learned single judge paragraph. Learned single judge by an order dated 26 March 2021 dismissed the writ petition inter alia on the following grounds. Number 1, the petitioner the appellant had not furnished the particulars of the members of the association who was the petitioner before the learned single judge. Full stop. Neither the dates of the entry of the persons, entry of the members, nor the date of their retirement was indicated. Number 2, it was not even stated as to whether the members of the appellant association have superannuated between 1/1/1986 to 31/10/1987. Number 3, from the representation submitted on behalf of the appellant, the dates of retirement of any of the employees of the association could not be is not forthcoming. Number 4, in the absence of any details, it is not in the absence of any detail. In the absence of any details, the appellant association had failed to demonstrate that any rights of its members are being infringed. Paragraph. Thus, from perusal of the reasons assigned by learned single judge in paragraph 5 to paragraph 8 of the order, it is evident that the writ petition preferred by the appellant has been dismissed on the ground that the appellant has failed to furnish the particulars so as to prima facie make out whether they are entitled to stake a claim for updation of pension. Full stop. The order passed by the learned single judge does not suffer from any infirmity warranting interference of this court in this intra-court appeal in the result. Hence and is hereby dismissed.
26.
Right, dismissed. However, appellant is so advised shall be at liberty to submit fresh representation with regard to their claim for updation of pension. When they say with the aforesaid liberty, the appeal is dismissed. Don't put us in an embarrassing position, right? Otherwise, you will convey to the client that court has suggested. It's not our job to suggest anything. You should have realized. Yeah. I will hear you after what is direction to consider OTS proposal, right? All right. Yes. Learned counsel for the parties submit that there is a possibility of an amicable settlement of the dispute. They undertake that the parties shall appear before Bangalore Mediation Center on 3rd of June 2022 at what time? 3 at 2:30, 3 p.m. Good.
So for DRT, he said, DRT mentions they are fine. I will not.
Yes, you tell. Should we write it?
So for DRT, he said, we will not. Here they are fine against you. And we have deposited all the amount.
DRT is quoted for final judgment. That state is there.
What precipitated? Yes, what precipitated? What is there? I mean, you have been directed to consider their OTS proposal. What is wrong? What is wrong with this order? The court has only said that you consider, you reject whatever, not proposal, not in accordance with guideline, whatever stage not considered. What is it? Oh, is it so?
So far as not we have not we loan of 8 crore 60 lakhs. As against that, we have paid
except
60.85 crore.
Consider and accept. So what is being done? Have they filed contempt?
No.
Then what precipitated? When he is saying that, he will appear before the mediation center, what precipitated? Vacation, you will not be here. Nothing can be precipitated. What precipitated? We want to understand. What is? Have they filed any contempt? Whether your officer is being sent to jail? Nothing. What precipitated?
This
closed. So it will be revived. No, you will have to argue. You will have to argue. He said that the parties will appear 3rd June. We have said 3rd June. Now you are arguing despite that. I don't know who is appearing. Both of you are appearing. So what did he tell us? You tell us, what did he tell us? What did he tell us? We have fixed it for 3rd of June. And there is no contempt petition filed by him. Then what? That's what we have asked the senior counsel. What precipitated? Nothing. Nobody is precipitating anything. Enjoy the vacation.
Number 27. There are many.
Retention of petitioners that the deputy commissioner also taken into consideration tendencies to the over 730, wherein compromise decree had been challenged. By way of the improved order, the deputy commissioner allowed the release. That the name is the deputy record acting on the compromise decree. No, this is correct. But the fact remains this.
I was not a party to OS 989. So the compromise between the two of the respondents here and others, without my presence, in respect of my rights.
But what you have filed OS 739.
989 was filed inter se between respondents. Inter se. That is 5 and 6. And others filed OS number 989, which they compromise. Page 155 and 250. Plate. They go before the local others without my presence. They compromise the matter. Coming to know of it, I find OS
31 of 2000.
What you just said?
2009 or not, there is no order.
I'm not a party.
No, it will be subject to the result of.
Based on the compromise, there is a mutation.
What has happened to your suit?
Pending.
Deputy Commissioner has said it will be subject to the result of your suit.
That's what Malad, the point is, Deputy Commissioner has not considered the fact that I was not a party in CCA. Anyway, that's about it. That's the only ground.
The revenue entries either way doesn't confer any title. What happens? Eventually you will get title only if you succeed in 731.
Seek necessary order in your suit.
In 731, restraining them from alienation. Nothing wrong. Or we will grant you liberty, you withdraw with the liberty learned senior counsel after arguing the matter to some extent learned. This intra-court appeal has been filed against order dated 14th of September 2021, passed by learned single judge, by which petition preferred by the appellant has been dismissed. After arguing the matter to some extent, learned senior counsel for the appellants seeks leave of this court to withdraw the appeal with the liberty to file an application for injunction, file an application seeking injunction in OS number 731/2009. Needless to state that in case such an application is filed, the trial court shall decide the same in accordance with law after affording an opportunity of hearing to the parties. Accordingly, expeditiously, accordingly, the appeal is disposed of.
Venugopal here.
Yes, please, Rolla. Next week.
Next Monday.
19th. Mark the presence learned counsel for the appellant praise for adjournment on the ground that the arguing counsel is not available. List on 19th April.
I'm appearing for the petitioner's counsel. Annexure A, my lord, the validity of the rules have been called in question, compelling, my lord, the schools, my lord, to teach the first language or the second language as Kannada, my lord.
Responded.
My lord, they have imposed, my lord, a penalty to pay, my lord, as per Annexure B, my lord.
Consider after they are served. Consider the prayer. The education institution 25%, right? Where is the order? Page 52. Yes. 52, same order. Heard on the question of admission as well as in learned counsel for the petitioner submits that petition. Same thing involving similar issue has been entertained. Interim order has been granted and an interim order has been granted in support of a submission. Reliance has been placed on an order dated 29/3/2022 passed in WP number 6713/2022. In view of proposed submission and with a view to maintain parity, it is directed that in case petitioner deposits 25% of the total demand for the current financial year within a period of 4 weeks from today, the impugned notice dated 19/3/2022 shall remain state the next date of hearing this for analogous hearing along with WP number 14283/21 and WP number 6713/2022.
For dispensation.
A dispensation is allowed. IA 1. Beginning you write IA number 32 and 33 order.
31. The artist complete clear.
Oh, senior has come. Yes. Yes. Hey, you have to indeed write KE and done it. File. Application filed, right? You have filed an application. What? Where is the application for implement? Acha, you
As per our on the last date when we
direction. Oh, you have done it.
Yes, yes.
Oh, yes. What is it, Mr.? No, your case is that. Acha, you first relax. We will take it up afterwards.
This was published. And the very next time I responded to college about 9 a.m. When they asked me to wait in the I waited at 12:45 p.m.
No, you were allotted a seat. Where you were you allotted a seat?
I am not.
Then?
Even now is not. Yes, college has given admission to a student who is not lower in the rank.
Which is that student? Who is that? Sorry, but info.
I waited up to 4:30 minutes. And we came to know that they have granted the seat.
Who is that person?
How do you know?
I know because I was there up to 4:30 p.m. Because from morning 9 a.m. to 4:30 I was there.
How do you know that right?
So there were premises, people were talking that a less eligible candidate than the petitioner has been admitted. So they told you that you have not been admitted. So who told? Who told in Varanda? Hey, Mr. West. There are this thing, wait, this thing. What are the averments? Nothing.
Have you sought for the information?
Even if I apply it will take more time. But the time everything
No, at least you should have made an application, right? Saying petitioner came to know from whom. You have not said in para 9. That's the problem. We are testing your submission in the light of pleadings. You have not said so. That so and so told me nothing. petitioner came to know that respondent candidate was secured less than 140 marks? Which candidate? Who told you? How do you came to know? This all. He will have to file an affidavit, not like this. What to do, Mr. Ramesh?
Now the last date itself is over. Unless one person is displaced, he cannot. Then college has to answer this because these their vacancies.
But this the government is absolutely vague, right? No person. How can be a person be who admission be cancelled who is not even a party? How can we give a direction? Authority counsel for the petitioner undertakes to serve, to take out hand summons for service of notice on respondent number 2 college. Learned counsel prays that the matter be listed on 19th April. 19th, list on 19th April. Please understand, you will have to file an affidavit. Who told you? What is the find out? Make an application under Right to Information Act. At least you should tell us. Not like this.
Government advocate.
We have entertained, right, similar petitions.
Particulars.
Huh?
You have to give the particulars.
You have to supply particulars. Give a copy of the petition to this.
Here, Mr. Prakash is here.
Mr. You are. We have dealt with similar petitions, right? Yes. Like they have given a chart, right? What is the amount? This case, 55 lakhs is the demand. How much will you pay?
Lakhs, 14 lakhs.
There is no amendment, right? That case also, Mr. Bhanu Prakash, we have given, we have asked the council to give you a copy. Please seek instructions. This is your. This will be corrected here only. Then the order will begin. But we should notice the these people. Council for the petition. Submit that an amount of here 55 lakhs. Everything will remain the same. Here 14 lakhs. And it will be all 14 lakhs. That is there. Yes. It along with WP number. Office is directed to reflect the views of Mr. Bhanu Prakash as counsel for in the beginning itself. After the issue notice.
35. Sandeep, we got dominated with
challenging the order in terms of the tribunal has
Have we entertained similar case?
where there also the petition that is not waiver of the pre-deposit.
But several provisions have been upheld, right, which require pre-deposit of an amount.
I'm not contending that the pre-deposit itself is done. I'm only saying that the 30% which is to be paid. In this case, perhaps we consider because taking stay of the balance 70%. 63 of the balance which has reduced the initial fee.
But you are challenging the provision, right? 63, 59. Yes. Yes.
Shall be in the prescribed form, shall be verified in the prescribed manner, and referred to any person other than an officer employed by the state government or commissioner under subsection 1. Shall be accompanied by proof of payment of 30% of the tax or other amount disputed, and also fee equal to 2% of the amount of assessment objected to, provided that the sum payable in no case be less than rupees 200 or more than 1,000 rupees. The provisos may not be relevant. My submission is that the provision for stay is actually provided at section 63(7) at the bottom. There too, in fact, the tribunal specifically says the tribunal may in its discretion stay payment of 70% of the tax or other amount disputed if the appellant makes payment of 30% of tax or other amount disputed along with the prescribed form of appeal. My submission is that if the intention of the legislature was that 30% shall be a mandatory period to entertain the appeal, 63(7) itself would be a notice solution. There would be no requirement for the legislature to provide that the balance 70% shall be stayed. If I pay as a 63(4), 63(7), the question of asking for stay would not arise. In fact, in similar tax enactments under the Central Excise and Customs law, the wording is very clear when it says that the tribunal, that is the customs tribunal, shall not entertain an appeal unless this deposit is made. In this case, the provisions do not seem to suggest that it is a pre-deposit for maintainability of the appeal. It is if I make this payment, I am entitled to stay. If I don't make the payment, I'm opening myself to the threat of recovery by the respondents. My humble submission is that this provision we need to be considered to see whether it is a pre-deposit for the appeal to be maintainable or whether only simply for stay. If the common error, then the tribunal is right and my appeals are automatically to be dismissed. But if it is the latter, then whether this is to be.
But what do you say when the memo of appeal shall be accompanied by proof of payment of 30% of the tax? That means it's a requirement. You will have to show that how it is arbitrary. There's no question about that. It's a requirement. Memo of appeal has to accompany with the proof of payment of 30% of the tax. That it's a requirement.
There are decisions to say that even though the word shall is there, in certain contexts now it should be read as may, especially because it's a procedural provision. Because the 63(4) in fact prescribes that I filed up in a prescribed form, prescribed manner, and it should be accompanied by a fee. That fee, my lord, is my humble submission, the appellate fee for the tribunal. But the 30% is only for stay. In fact, this is the second appeal for the tribunal. The first appeal is there too, my lord, I am entitled to file an appeal, notwithstanding any payment made. If I want to stay, then I'm supposed to pay 30%. If I don't, again, I'm okay.
How is this arbitrary, or what? The parliament, the state legislature has power to enact that provision to circumscribe the right to file an appeal, right? Right to file an appeal is a creature of statute. It is subject to such terms and conditions. So you are basically challenging it on what ground? Violative of Article 14. What is Article 14 about it?
Demonstrate the fact how the arbitrariness is being demonstrated.
No, provision. Independently. We are asking you all this because you are declaring section 63 is ultra virus, what mandatory this thing.
Try to demonstrate how it is arbitrary in this case.
Arbitrary, unjust, and so you are seeking that provision of section 16(4) be struck down, right?
Read down to read that the requirement of 30%, we only are seeking sake of the balance 70%.
Where do we get it from?
Yes. I just for a minute, I just take to the fact only to show how it is arbitrary and deals with petitions like this arbitrary. In this case, perhaps the returns are filed admittedly belatedly. It can be output type of 50%.
Now it is reduced to 30%. It was 50%.
50% is reduced to 30%, right, by amendment.
Because the larger section from the 30%. I'll only just say what happened is I filed my return, monthly returns belatedly. Then the output server, input server.
Something, 1 minute. What we want to understand is that if you are arguing facts, that's different. If you are challenging the validity of a provision, we are putting you queries in that context. Validity of provision, legislative competence, or violation of fundamental rights. You don't dispute that state legislature has power to enact Karnataka Value Added Tax Act and the provision like section 63, right? It has power to enact the law, right? So now what is the challenge? So it is arbitrary. Violative of Article 14. How? What have you pleaded? No, what this is why we are asking you, we have dealt with one issue of GST on tobacco and tobacco products. We have heard all these arguments were raised, and we found that in the writ petition, levy was not assailed, that it is violative. It was not even pleaded that it is violative of Article 14. I mean, there are decisions of the court which say that you have to plead and prove. So that's why we are asking what is it? What have you pleaded? How it offends Article 14? What is it? How it is arbitrary? Well, many such provisions have been upheld, you would agree, right? Many such provisions directing pre-deposit of the amount have been upheld. Legislature, your right to appeal is a statutory right. It's a second appeal, not for it's that you are being condemned. You have had this thing after adjudication. You preferred the right of you had an appeal. Thereafter, at the second appellate stage, the legislature has circumscribed your right by saying that in case you have lost from both the forums, deposit 30%. What is wrong? Please tell us.
It's a premium on office the revenue authorities to pass an order raising exorbitant demands without any basis, because I will not be able to assail those orders if I don't have the financial ability. So it places equally placed person in the sense if I am agreed by an order. If I have a
in that case, Mr. Then in such a case, I mean, in the facts of that case, you can seek, I mean, a waiver or whatever or this thing. But no. But we are on that's why we told you we have not yet adverted to the facts. We are on the validity of the how it is. That's what we are asking you. If you confine it to the facts of the case, then that is different. Because we don't this thing prima facie see how a provision is bad.
I appreciate what you suggestion. In fact, my alternate first way manner is actually to directly tribunal to consider without insisting on payment of fee. For waiver is what I'm essentially sought from. If we permitted to file a memo, I'll withdraw the prayer with respect to challenging the virus and respect it only by the waiver of the fee deposit.
How can we this thing now? You tell us how can we waive it? When the statute itself prescribes.
There are orders passed to this person.
All right, so learned counsel for the petitioner, after arguing the matter to some extent, states that he shall file a memo seeking withdrawal of the prayer made in the writ petition, in which challenge is made to the validity of section 63 within bracket 4 of the Karnataka Value Added Tax Act. We will file a memo during the course of the day. In view of a court's submission, let the writ petition be listed before the appropriate bench as per roster. Make a mention before a single judge. Now we have said so, right? You can make a mention.
36.
Yes, Mr. 148. Oh, what is the notice? You have that order 148. 15,421. For years, which year? Ah, yes. You should argue these 18. 9 high courts or how many high courts in your favor? 10, except Chhattisgarh. Everything including Bombay High Court, latest is Bombay High Court, right? Yes. Huh? Huh? But what is happening every day? We are getting 2, 3, 4 cases. I mean, instead of so we should decide it instead of Mr. A. Shankar, senior counsel with Mr. M. Lava, counsel for the applicant, issue notice to respond. Yes, yes, along with Mr. No, along with issue notice to respondent learned. This all order is there. Dated, dated 15. See here, 15/4 for assessment years. This 4, 5.
Government
18. Oh, admission cancelled. Where is that order?
Go to the other.
But supposing if he has not furnished NOC.
It's already been allotted to the respondent number 6.
Huh?
This has to go to.
He submitted NOC. It was verified by the KDD. When I accepted it, given admission order, and the institution where he
So why have you cancelled?
Now the says that he did not give his NOC and get it.
But he is saying that he let them verify. 19th we will take up. What is there? Find out 19th. 20th. 20th. Fine. Learned counsel. Yes. Learned counsel for the petitioner. You take out hand summons to others. Issue notice. Notice on behalf of respondent 1 and 2 is accepted by learned additional government advocate. Issue emergent notice to learned counsel for the petitioner submits that she shall serve respondent number 3 and 5. 3 and 5 and 6. She will take out 3, 4. 3 and 4. Shall serve the copies on standing counsel for counsels for respondent 3 and 4 and shall take out and summons to respondent number 5 and 6. Learned counsel, before that you write learned counsel for the petitioner submits that the petitioner was allotted a seat in first round of counseling in MD respiratory medicine in respondent number 5 is Q. Where? Which institute? In Rajiv Gandhi Institute of Chest Medicine, right? Chest disease, you say medicine here, chest diseases. However wide communication date, but this is 25th February 2022. The allotment, the allotment of seat has been cancelled without issuing any notice to the petitioner. In view, then learned council undertakes to so and so 3 and 4, and then take out hand summons on 5 and 6, and list on which date, madam? 20th April 2020. You have to just find out why.
Permission number 38. Yeah.
You want admission of the appeal, right? Appeal is admitted for hearing.
There's an order on 10/11/21.
10/11/21. What is the order? Oh, that's why. 20th April. 20th April. Mark it.
Not made. They condone, not condone will be revived.
Oh, yes. They see the order, what is 10/11/21. It counsel for the applicant praise for adjournment on the ground that arguing counsel is not available. Just on 20th April 2020. Yeah.
Number 39. Kumar.
Admit it, what is there? The admission, right? It has to be heard. Appeal is admitted for hearing. Let the same be listed for final hearing immediately after ensuing summer vacation.
Demand in this matter. It is not.
So we will hear it. Whatever. 30th May for order on final 30th May 2020.
Number 40. CR Subramania.
Oh. Compromise petition. This petition. No. This petition has been filed against judgment and decree dated 3rd of June 2021, passed by the family court, by which petition filed by the appellant under section 13(1) within bracket small Roman 1 and A bracket close of the Hindu Marriage Act has been dismissed. Paragraph. When the matter was taken up today, learned counsel for the parties have submitted that the matter has been amicably settled between the parties, and they have attention of this court has also been invited to a memo for compromise, which is duly signed by the council as well as their council as well as the parties. The terms and conditions are as follows: 1, 2, and 3. Line below to the accordingly the judgment and decree dated so and so passed in MC number 39 of 2018 is modified and appeal is disposed of.
What has happened to our hand? What has happened to our hand?
So say parties along with their
accident
counsel present. 1, 2, 3.
Mohan DK.
For petitioner, my lord. My lord, the respondent herein had filed a petition before the trial court for restitution of conjugal rights, my lord. And the same was contested by the petitioner herein, who is the wife. But during the pendency of the petition got transferred to a different court and the parties were unaware, my lord. And they could not appear before the transferred court. As a result of which the petitioner herein could not lead her evidence.
Which matter?
Serial number 41, my lord.
In this case, petition under
Petition
section 13
section 13 is filed.
allowed.
Sorry, my lord.
The petition under section 13.
Yes, my lord. No, initially it was for restitution of conjugal rights, my lord.
The decree of divorce has been granted, right?
Yes, my lord. That was based on the restitution of conjugal rights, my lord. But the restitution of conjugal, in restitution of conjugal. No, my lord.
We will have to hear the other side. We will have to admit the appeal, right?
Yes, but in the meantime, the respondent is making hectic efforts to marry for the third time, my lord. If that is allowed, if that is allowed, then the very petition would get infectious, my lord.
Question of admission of state. IA 1 of 2020 appeal is admitted for hearing. Issue notice. After hearing learned counsel for the appellant, it is directed that operation in effect of the impugned order dated 21st August 2020 passed in MC number 680/2019 insofar as it pertains to resolution of marriage shall remain state till next date of hearing.
Obligement.
In the beginning of this, your record.
42. Rama
Small bit is there, my lord, and they also could not come to find a something they also could have.
Of the present list on 18th of April 2020. Will be called, right? I mean, we don't know what. Let him come. Let's see.
44. We said something.
Let's 44. I appear for a review petitioner in 44.1.
It will be called
44.1. I appear.
Password.
And in which case it may be taken up on some other day. Let's next week your lordships may have it. Monday, Tuesday, your lordships. Tuesday.
Krishna. Fine, that will be condoned. So Wednesday, 20th April. List learned counsel for the appellant petitioner praised for adjournment list on 20th April 2022.
45.
45. I'm appearing for the appellant, my lord. The appellants are brother and sisters of deceased Sudhar Kaushik. Who died. No, my lord, one submission, my lord. One submission. My lord, we have spent about 8 to 10 lakhs to save our brother. And added to that, my lord, the bank account, about 47 lakhs are remaining there, my lord. And only the ground urged, rejected by the learned civil judge is that, my lord, the bank passbook has not been produced. My lord, your lordship very well know that, my lord, the latest private banks will not issue bank passbook, my lord. The statement exhibit P8 clearly says that the account is standing in the deceased name and account number and amount remaining. That is sufficient, my lord, but learned judge has said that no, you have not produced bank statement or not examined the bank manager. My lord, examining the bank manager does not arise for because when a banker issues a letter, it is admissible in evidence. Exhibit P8, they doubted by the learned civil judge. My lord, in para 9, he has doubted. Only there are no other respondent, my lord. It has to be, your lordship has to, my lord, I may be given date, my lord. I'm hard pressed for, I lost my money. My lord, I may.
We will consider your argument, whatever you have said, we will consider it. We'll pass orders.
Date, yes, my lord. Yes, my lord. Yes, my lord. I'm agreeable, my lord. I'm agreeable. I did not follow. I'm grateful, my lord. I'm grateful.
46, Srimati Vaishali Hegde.
Right. He'll admit records. Records with all. Oh. Oh.
Investments are not shown from where the investments have come. Let's be rather details. It's not security at best. This is not where investments are made for these assets. When you are having the to exercise the right, that is having the right. You have to wait 30 years.
Which paragraph of the judgment they have said?
Starting from 30, page 30. Running page 30. On 14/4/2020. This one also clearly show the signatures are the only legal heirs. So that there is no dispute. Having said that way, if there are discussions paragraph 14, there is a lifetime of so and so, he made investments to the other company.
All right. Pass an order.
47. This Shankar Reddy.
Yes. Happened dismissed. Admitted for hearing. Record is there. Record. Okay.
Same party. Same party. 49 we may have to grant an interim. 49 we may have to grant an interim.
47, which cases you called?
47. 47 is called. 49 is also common order.
Yes. 49. On the question of admitted just along with MFA number 968 of 2022 heard on IA 1 of 2022. After hearing learned counsel for the appellant, it is directed that no coercive action shall be taken against the appellant in the execution proceeding till next date of hearing.
JP Darshan.
Sardines and water dismissed on the ground of
after vacation. No territory.
No.
What come? I will send for. I will consider it, madam, after just now. Yesterday only we have decided your case. What is, we are not other cases also to be dealt with, right? After vacation, record office is directed to secure the record of the trial court list after ensuing summer vacation.
50.
What undertaking?
Therefore, we could take some time to hear this. Not to have it after vacation. One is there is contempt filed by me before the order was released. But the appellant is directed to appeal. Secondly, even appeal, she doesn't say that.
In any case, you are appearing, right? You file an
The appellant is not saying that. I have answered every question. But I am not saying because. I'm not getting all this. One solution. The guardians in what case?
But if you are seeking, we don't know. We'll see it after vacation. We will know it after vacation. Which date after vacation? Which date? 7 June. 7/6. Let this appeal be listed for orders on admission on 7 June 2022. The undertaking, learned senior counsel for respondent submit that he shall not precipitate the matter till next date of hearing. Then list on 7th June 2020. He is admitted for hearing record. Issue notice record. 52. 52 what is record? 52 admit issue notice record, then heard on IA 1 of 22. What is impugned decree insofar as it grants decree of divorce?
Yes.
Dissolution of marriage dated 27 January 2022 state. Till next date of it. Wait. Don't be in a hurry to call. There is nothing, no urgent. Vaishali Hegde, Learned Counsel for the appellant. This appeal under section 372, 384 of the Indian Succession Act 1925 has been filed against order dated 20th January 2022, by which the petition preferred by the appellant under section 372 of the Indian Succession Act has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that appellant number 1 is the wife of late Shri Balaji Narayan, whereas appellant number 2 is the minor daughter and appellant number 3 is the mother of the deceased. Full stop. Of the disease. Full stop. The first appellant was married to late Balaji Narayan on 28/3/2007. Out of the wedlock, appellant number 2 was born on 26/3/2012. Aforesaid Balaji Narayan died intestate on 14/4/2020, leaving behind the appellants. Full stop. Thereupon the leaving behind the appellants. Full stop. The appellant, the deceased during his lifetime had invested money in shares, mutual funds, and was given employees stock options by the company. Namely Cisco, where he was employed. Full stop. The shares and mutual funds are in DMAT and are being managed by ICICI Securities. Full stop. The appellants thereupon filed a petition under section 372 of the Indian Succession Act 1925 hereinafter Act, seeking for issuance of certificate in favor of appellants number 2 and appellants number 1 and 2. The trial court before the trial court, before what objections were published, they read. The notice was published in the newspapers to the public in general, inviting the objections. However, no objections were preferred. Paragraph. The appellants paragraph. The appellants thereafter, appellant number 1 thereafter examined herself as PW1 and got examined 11 documents, namely Exhibit P1 to P11. Full stop. The trial court, however, by an order dated 20th January 2022, dismissed the petition filed by the appellants under section 372 on the ground that the petitioners have not, that the appellants have not produced, that there is no document on record to hold that deceased had made investment in various companies. It was further held that the court cannot issue succession certificate for mere asking. It was also held that the petitioners, that the appellants have miserably failed to prove that during the lifetime, the deceased had made any investment in the companies and was holding a credit card in State Bank of India. Accordingly, then it will succumb. Accordingly, the petition under section 372, right, of the act was dismissed. Now, inter alia dismissed. We have begun. Inter alia held. It will not come in the beginning. Here, paragraph how it begins. Exhibited documents P1 to P11.
Trial court, however, by an order dated 21/22 dismissed the petition filed by Definite Sunday.
Inter alia held, not dismissed. That's what I'm saying. Dismissed, inter alia held. And it will come. It was accordingly dismissed in the aforesaid factual background. This appeal has been filed. Learned counsel for the appellant. Learned. Nothing. We don't require. All right, you please. Learned counsel for the learned counsel for the appellant submits that the learned counsel for the appellant submitted that the trial court ought to have appreciated that the appellants are the legal representatives of appellants are the only legal representative of the deceased. Full stop. It was learned counsel for the appellant submitted that the trial court itself had recorded a finding that the appellants are the only legal representatives of the deceased. In para 4 of the judgment, it is further submitted that the trial court ought to have appreciated that the secondary evidence of the emails, namely Exhibit 2P, P9 to P11 had been produced, and the appellants had also filed the sales certificates or stock option certificates. It is also submitted that the accounts that the shares, equities and dividends were being held by the deceased in a demat form, and hard copies of the shares or equities are not issued. Full stop. It is paragraph. We have considered the submission made by learned counsel for the appellant and have perused the record. The trial court in paragraph 4 of the judgment has recorded the finding that despite publication,
starts from para 9. Para 12.
Oh, para nobody appeared. Right?
Para 12 on Jerusalem.
So this para 4 is institution that nobody has appeared. No objection. Para 4 of the judgment has recorded a finding that after paper publication to public in general, inviting the objections, no objections have been preferred. Full stop. The trial court in para 9 of the judgment has held that the appellants are entitled to the estate of the deceased. Full stop. The full stop. The state of the deceased. The appellants.
They are the only legal heirs of
in para 9, instead of para 9, you say para 12. Para 12 has recorded a finding that they are only legal heirs of deceased. Full stop. The full stop. The appellants, full stop. It is pertinent to note that the shares, equities, and dividends held by the deceased were in a demat form. Full stop. The portfolio management of the shares and equities was being managed by ICICI Securities, and in documents, namely Exhibit P9 to P11, the name of the deceased was mentioned, and it was stated that equities, shares, mutual funds were being held by the deceased as on 30th January 2021. Full stop. The appellants had also furnished of the dividends, not appellant said also, the dividends and equity which had accrued to the deceased in the company, namely Cisco, was also shown by auditors of the firm. Full stop. Auditors of the firm. Full stop. There, full stop. In the appellants had also adduced the secondary evidence, namely the emails exhibit P9 to P11 in support of their contention. Full stop. In the absence of any evidence to the contrary, comma, the trial court ought not to have discarded the documents adduced by the appellants. Full stop. It is pertinent to mention here that there was no objection by anyone that the amount in question in respect of which the succession certificate was sought was not held by the deceased. Full stop. Therefore, the finding recorded by the trial court is erroneous, and findings recorded by the trial court are erroneous. The judgment dated so and so is set aside, and the petition filed by the appellants under section 372 of the Act is allowed. What happened to 30? Their number 17. And for the appellant, even when matter is called in second round, awaiting appears. Current counsel for the appellant hearing of the appeal is deferred list after ensuing summarization.
43.
What is it, Mr. What stay we have to hear? No final hearing, only stay we will decide. What is it? Where?
Filed under the respondent. Page 68 was to get the plea.
What is the interim relief which you are seeking? What is the interim relief which you are seeking?
For stay of not of the order of injunction. So this is a blanket injunction that is granted against me. But immediately, I am not a borrower nor a guarantor. So the transaction not related to one who is a businessman not in Dubai.
No, but granting the stay means allowing the appeal itself, Mr. Please understand how that can prayer be granted prima facie without entering into anything.
The laws that are applicable are Dubai laws, that is UAE laws are applicable. And not agreement, guarantee agreement.
Let's see what go ahead. Yes, what?
Well, also can you turn to page 68 for a moment?
No, please, what facts you tell us what is it?
But on 8/5/2017 and on 10/9/2017 and 10/10/2019, but very facilities not been given. Enhanced not on various ways. I think there was a different modular concepts not limited, which is a Dubai company. But this fourth defendant not had also executed along with second defendant and first defendant not a guarantee in care of not the plaintiff bank. But I am not a party to any of those transactions. I am a company in India. Now, Lord, what has happened is in 2020, Lord, the defendant Lord is said to have not paid the payments in respect of 1/9/2020. Not the default occurred. after which no payments have not been made by not the different number 4 company, which not is in Dubai. Again, the different number 4 company and not Mr. VR City and not others. Suit is filed not before the court not in Dubai for the recovery of money. And that suit not has been decreed not is what we are told. Now, not in respect of not the appellate reform laws, there is no suit that is filed. I am different number 3 before the trial. So no suit is filed not before the court in Dubai. The suit is filed not before the trial court not in Bangalore, saying that not insofar as I am concerned, in fact the plaintiff also does not disclose the cause of action as against me. It says not the money that is paid to defendant number 4 is not siphoned off and paid to defendant number 3, because defendant number 4 not has shareholding not in defendant number 3, so also defendant number 2, and therefore not the allegation is the money has been siphoned off to defendant number 3 from the money that has been paid not to defendant number 4.
What is the restraint order? Don't alienate your assets, right?
So not only that, it is quite likely. It's not paid to order is not different than the number 3 is attorney, agent, servants, instrument, representative.
You are defendant number 3.
Acting on its behalf or claiming to or under them, from transferring, alienating, or otherwise dealing with, disposing of, or creating any third party interest, or extending any loan or guarantee, or encumbering any manner, any property and assets in any manner whatsoever during subsistence of personal guarantee, dated so and so, as long as any money is owing under the credit facility agreement, dated so and so. So, I am concerned, I am not a party to any of these transactions. The only allegation as against me not in the plea is
transaction 10/3/2019.
That is in respect of defendant number 4. Defendant number 4.
Is any bank guarantee and you are not party to the credit facility agreement?
I am not party to the credit facility. That is not an admitted fact. The only allegation as against me not is limited to saying that not according to them, defendant number 4 has not transferred money to defendant number 3, and that is siphoning of funds. That is why they say not defendant number 3 should not even not issue any loan or guarantee or deal with in any manner any problem.
What properties have been
No property has been described from the application. That is also another point. The complete blanket not exemption that is called. Kindly turn to page 113. Their application. One application. Secondly, there is no schedule. It does not kindly not turn to, but the memo note which I filed on 19/3/2022, which contains not the guarantee agreement, which not yet not relied upon. The file note along 19/3/2022. 16th of March 2022 was filed.
Credit facility agreement. Where, what are you reading? We are trying to, this memo does not contain a date, so we are trying to make out whether it's same memo.
Filed on 16th.
In my copy, there is nothing.
Not dated.
Yes.
Filed on
What?
March 2020.
Not there.
Can I request not to turn to page 18? The guarantee agreement not which they rely upon. Can I straight away take clause 2, page 21, clause 15? I am not a party to the guarantee agreement as well. It also is not page 21. Clause 15. This guarantee shall be governed by and construed in accordance with laws of UAE. Any dispute connected with this agreement shall be submitted to the exclusive jurisdiction of UAE courts, and that shall not be construed so as to limit the right of the bank only to take proceedings against the guarantor in any other one or more jurisdictions. Insofar as the two things that arise from here. One, the law that is applicable by the parties, that is the guarantee agreement, is the law of UAE. Two, words, even according to the guarantee agreement, only the courts of Dubai would have jurisdiction. Whereas already they have approached the courts of Dubai against not others, and not during the pendency of the suit before the trial court, but a decree is passed not in their favor. There was another suit not which they had suppressed, which I'll point out to us. There's a credit facility agreement is in a manner wherein this NNC company, which was a project in relation to a hospital, but that project was approved not by the plaintiff bank, and not the fourth defendant, who is the company not in Dubai, was the contractor which had to deal not with the construction work, etc. But the money that was to be paid not to the suppliers. This is that not the credit facility agreement was made. The money not actually go to the supplier who in turn supply materials not for construction. So insofar as this not third defendant become not is concerned. But I have not had any transaction with the banks. But if you also kindly permit to take notes of the plain government, so far as I am concerned, the only indication is that there is siphoning of funds by the fourth defendant. In fact, what I have pointed out that I had transactions with the fourth defendant because they issued orders. I have company in India, I carry on transactions in India. Now, the government's not in the plane, if not to kindly permit to take notes of plane from which starts at page 68. Permit you to take notes to the leading insofar as what I am concerned, which is not at page 4. I refer to what the liability of the fourth defendant in defendant 1 and 2 under personal guarantee para 32. Please permit me to take note to page 85, para 37. Occurrence of default, the plaintiff has also conducted inquiries into the affairs of defendant number 3 company by examining its financial statements filed with the Ministry of Corporate Affairs for the financial year so and so. It is pertinent to note that on perusal of balance sheet filed by defendant number 3 for the financial year ending 31st of March 2018, the following suspicious actions become questionable. But these suspicious actions not ultimately not para 39. They refer to the transactions between the year 2017 to 19. In view of the above, the total amount of the related party transactions for the financial year 2017-18 and 18-19 between different number 4, different number 3 stands at rupees 79 crores so and so. Whereas the total amount of related party transactions for the financial year 15-16, 16-17 between different number 3 and 4 stood at rupees 99 lakhs. I'm going to kindly permit to take notes to the in which what they say the default is occurred. Page 18, para 55. The first default note occurred in 1/2/2020. Para 25 note at page 18. Fifth line note in that paragraph. Start with agreed terms. Then what the next sentence? The first default occurred on 1/2/2020 when defendant number 4 defaulted in making the repayment under the trust listed limit loan. But these transfers not been made to be in respect of different transactions and is not siphoning of funds. But the contract itself not stipulates that the courts at Dubai would have jurisdiction and the law that is applicable is the Dubai laws. Now, the trial court does not properly appreciate this contention. And even with regard to jurisdiction, because defendant number 1 purchased the property in India, and that is a cause of action that is ever into claim. Insofar as I am concerned, the cause of action paragraph, there is not even whisper as to how I am responsible or how the court in Bangalore would get jurisdiction. I'm sorry, but if not permitted, I just take note to the cause of action paragraph as well. But page 96. Submitted as a cause of action for filing the present suit arose on so and so when the plaintiff granted credit facility to defendant number 4. On so and so when the plaintiff granted additional finance facility to defendant number 4. On so and so when credit facility agreement was amended, enhanced by way of extension letter with defendant number 1 and 2 and Dr. B.R. Shetty giving personal guarantees. Then 4 on 19/3/2020, plaintiff issued demand notice to defendant number 4, defendant number 1, 2 and others. Then plaintiff instituted substantive recovery proceedings against defendant number 4, defendant number 1 and 2 and others before the honorable first instance court in subsequent dates when defendant failed to honor the obligation. But this is their cause of action insofar as the suit in Bangalore is concerned. But the defendant number 3 company is not situated in Bangalore. It is situated not in Chennai. Can I request not to kindly turn to the order of the trial court? It starts not page 82, not to straight away not turn to page 56. There is a specific contention that the court at Bangalore has no jurisdiction. Other than by virtue of the agreement itself, the courts of Dubai would have jurisdiction. 21 or so. When senior counsel for the plaintiff interferes.
What stay do you want, sir? We are not inclined to grant an absolute stay as we told you. It amounts to allowing the appeal itself. Can't be granted, right? All this thing, we will admit your appeal. We told you we are considering the prayer for only stay. What we can't grant an absolute sort of stay of the order granting injunction. We can understand that if you have some difficulty in operating as you told us, but it can't be, you can't be permitted to alienate. What happens to their list, supposing if they are right in saying this has to be heard, right?
For admission after vacation, immediately after vacation, not have it. The understanding the matter will be heard.
Of course. Yes, Mr. Nagar. Which date? Tell us. Whatever date after vacation. Yes, Mr. Nagar. Mark the presence, Mr. P. N. Manmohan, learned counsel for the applicant. Mr. Nagar and learned senior counsel for respondent number 1 and 2. 1 and 2. 1 and 2. Or respondent. Let the appeal be listed for final disposal on 26th May.
There is one objection, Lord. In the appeal, the High Court rules requires that all parties should lower court should be carried as parties.
Yes.
They cannot made them. There is a note to not put in the cost title. They must make them parties, not because they may have to come and face it.
Yes, learned counsel for the appellant undertakes to impede the.
They are not necessary parties.
But you can't delete. You have to. You could have told us that please dispense with service of notice on them, but you can't delete like on your own, right? Learned counsel for the fine. Learned counsel for the appellant undertakes to file an application for impleadment of other respondents before the trial court which have not been impleaded in this appeal. Let the appeal be listed for final disposal on what date? 26th May 2022. Final disposal we have said. Final disposal. At 2:30.
Group number 53, Srimati Akamahadevi Ramat, Sri Shanti Bhushan, Sri Krishna. Manmohan. Yes, Bharachandran.
The rural service.
Yes, notice.
$53.13. 1.3. Yes, madam, you appear. Yes, madam. What date, Mr. Ola?
Your Lordship, I'm appearing for the petitioner in 53.9.
Please tell which date. Oh, Mr. Shankar, you are also appearing. You say that rural service is not necessary. Oh. So which date? All of you tell us any date after vacation.
Your Lordship, just one submission. I'm appearing for the petitioner in 53.9. Your Lordship,
One minute. Nothing is being done. So as to call for your immediate intervention. So 7th, 8th, whatever. 7th June, 8th June. 7th June. Yes, Mr. Ola. Mr. Shankar. Yes, Mr. Naik. 7th June. Yes. We'll take it up on. Please mention on that day. 7th June. Mark the presence. Learned Council. Mark every list on 7th of June 2022. Sorry.
May I make a submission, my lord?
Your presence is also marked.
No, my lord. That 53.12. My name is not shown, my lord, for R1.
Yes.
Last time it was so ordered, my lord.
So in all the cases you are appearing, right?
No, my lord. That is only 53.12, and that too is that's a different matter, my lord. National Highway matter. It has come by mistake. It is posted along with this batch.
No, that has been de-linked.
Yes, my lord. And
why don't you come to court? Always appear through video conferencing. Why, mister? Don't come to court.
No, my lord.
Always request through video conferencing to mark your presence after the order is passed. 53.12 has been de-linked, right?
Yes.
The remaining cases will come up on 7th.
My name also may be shown, my lord, for respondent number.
Please give whatever list along with. Whatever, let these cases be decided, they will follow what is there. You are appearing in these cases. A list along with whatever. She will give the number.
Obliged, my lords.
That day only.
Your Honor, the state may be directed to file their objections also on the by the said date and serve it on us.
Directed. If they don't want to file, we can't compel them. Right? If they don't, she's not saying anything, madam.
Obliged, Your Lordship.
State. Right. She has filed objections in one of the cases.
We have not yet received the objection.
Please supply
Okay.
10 cases. So you please supply. You are appearing for which respondent, madam?
For 53.9.
Please supply, madam, copies. You supply in the learned additional government advocate undertakes to supply. Copies of objections to learned counsel for the petitioner as well as other counsel, as well as counsel for other respondents on or before next date of hearing. Based on 7/6. Counsel, we don't counsel. 53 is permitted to serve a copy on counsels, right? You say counsel for petitioners as well as counsel for other respondents. Yes. Write down this.
Very much obliged.
53.20. June, ma'am. Yes. Yes. Five.
54. 54, I appear for the contesting respondent.
318.
This one, 318.
The partner matter court may kindly recollect. By mistake, it was shown as further hearing.
You want to withdraw? That, why? You are well. You are feeling well, no? You are feeling well. You are all right, no? You should argue what is there. Case for adjournment. 59. Rest up. We don't know what is that. What has been done has been done. We don't change our order. Now call that 54. Waiting.
May I make a request? Serial number 54. 54.
These people. After,
yes.
After the break, take up.
Please. Wait. I assure the court I'll condense the submissions.
We expect you to conclude it within 20 minutes.
Very well. Very well.
ಚಂದ ಮಾಡಿದೆ
ಮೂವ್ ಮಾಡೋದಾಗ್ತದೆ. ಅದೇನಾಯ್ತು ಆಯ್ತು. ಸರ್ ಇಲ್ಲ ಮಾಡಿಲ್ಲ. ಇಲ್ಲ ಇದು ಅವರು ಕೊಟ್ಟರು. ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್, ಇನ್ನ 2:15 ರೀಚ್ ಆಗಿಲ್ಲ. ಇನ್ನ ರೀಚ್ ಆಗೋದು ಲೇಟ್, ಇನ್ನ ಲೇಟ್, ಇನ್ನ ಪಾರ್ಟ್ ರೋಡ್ ಮಾಡೋದು, ಇನ್ನ 50 ಮಾಡ್ತಾರೆ. ಹೇಳಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಂತ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಕೋರ್ಟ್ ಓಪನ್ ಆಗಿದೆ. ಐಫೋನ್ ಅದು ಇವಂದು ಕೋರ್ಟ್ ಓಪನ್ ಆಗಿಲ್ಲ. ಕೋರ್ಟ್ ಓಪನ್ ಆಗಿದ್ರೆ ಅದು ಓಪನ್ ಆಗತ್ತೆ. ಆಫ್ ಮಾಡಂತಾರೆ.
ಐಫೋನ್ ಸರ್ ಆಫ್ ಮಾಡಿ.
ಹಿಂಗ್ ಇಟ್ಬಿಟ್ಟು ಹೊರಟಾಗಿಲ್ಲ. ಇಲ್ಲ ಬಿಡಿ ಬಂದಿಲ್ಲ. ದೇವರಾಜ ಸುಮ್ನೆ ಯಾಕೆ ಟೆನ್ಷನ್ ಮಾಡ್ತೀಯ? ಅದೇ ಅಂತ ಅವ್ನ ಐಫೋನ್ ಅದು.
Hello. Hello.
Court officer? Open ಆಗಿದೆ ಅದು.
ಹೇಳಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 59 ಏನಾಯ್ತು ಮೇಡಮ್?
ಸೊ 59 ಅವರು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಟೈಮ್ ಕೇಳಿದ್ರು ಸರ್ ಅವರು.
ಟೈಮ್ ಕೇಳಿದ್ದಾರೆ. ಏನೋ ಡೇಟ್ ಏನಾದ್ರು ಫಿಕ್ಸ್ ಆಗಿದೆ ಮೇಡಮ್?
ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪಿಲೆಂಟ್ ಟೈಮ್ ಬೇಕು ಅಂತ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್
Thank you,
ವೆಕೇಶನ್ ಆಯ್ತು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದಿದೆ? ಸರ್ so what serial number is going on?
Hello.
First our matter,
The first round counsel for appellant appeared. He is not there now.
No, no. Then did not appear. Then did not appear.
He was there. What to do, Mr. Now? There is no husband, right?
This on Monday.
But none for the appellant even when matter is called in second round. Mr. B.K. Manjunath, learned counsel for respondent. Waiting appearance of learned counsel for the appellant. Hearing of the appeal is deferred list on Monday or Tuesday, 19th April.
You couldn't meet him, Mr. Manju? You couldn't meet him, Mr. Gush. Oh no. He appears. He was also for some time he was a government advocate also.
Hindu Arnat, R.B. Sadashivappa.
Fine लगेगा. fine levy warrant. It's a pending matter, madam. This is a pending matter 2018. So how would the other side, if it is listed like this, how would the other side know that it is listed? You told us that it should be taken up. We thought that it's urgent, fresh matter. Other side, how will come?
It should be ready with the file, madam.
Ready? How would he know that? Did you tell him that I am going to make a mention to the court today, and it is likely that the court will be matter may be listed? Please appreciate in a pending matter, in an appeal which is barred by limitation. You want it 4 years. You have slept over your rights, and suddenly you want. What is there? If warrant has been issued, it's only fine levy warrant, right? So what is it? You nothing wrong. No urgency. Yeah, sorry that we grant you indulgence in 20th April. Srimati Indur R. Raj, Learned Counsel for the appellant. This appeal is pending since before this court since 2018. However, on a mention being made today, however, a mention, not delete, however, a mention was made before this court by Learned Counsel for the appellant that the matter is of urgent, matter is urgent, and therefore, full stop. However, we were not informed that it is a pending appeal. Full stop. The counsel made a prayer that in view of urgency involved, the appeal should be taken today itself. Thereupon, we directed listing of the matter paragraph. However, on perusal of the record, it is evident that this appeal is pending before this court since 2018, and the counsel for respondent has no notice about listing of the appeal today itself. Therefore, the counsel for respondent has not appeared. Full stop. In the absence of counsel for respondent, no orders can be passed in this appeal. Hearing of the appeal is deferred. List on 20th April. No, madam, this is not fair on your part. Not fair. I mean, we rely on the counsel. What did you? No. Did you tell that other side is appearing? It's a pending matter. What is this? We thought it's a fresh matter, something urgent. You said some warrant is being issued. We thought why it has been issued. Why it has been issued? Why it has been issued?
For not payment of maintenance.
No, we are not hearing. We have passed an order. We have passed an order adjourning. We are just asking why it has been issued. Because you do something good to the society. That's why the warrant was issued against you. Why it was issued? We are asking. April, it will come back. 20th April. Not fair. You should be responsible. Don't do it. Don't. I mean, the whole this thing system is put under stress. I mean, they must have rushed to get it listed. Additional list has been prepared for nothing, for being adjourned. Not fair. You should have thought of how the counsel for respondent would appear and how we will pass an order in his absence. You should have thought. Yes.
May I please? I appear for respondent number 6. 2 facts before make my submission merits. The municipal council was constituted after a general election on 20th May 2018.
Case you are appearing, Mr.
I am
WP 44.
4457.
WP 4457, Mr.
Yes.
There are two petitions and there is a confusion always.
It's actually cut and paste.
Mr. If we pass a judgment in WP 4457, the other petition will also stand disposed of, right?
Yes. No, in fact, the other petition will go because it has not implicated me as a party. For non-joinder itself.
Just a minute. No, we need to have a proper petition. That's why we asked for the number.
Please, 4457 is
constituted on
20th May 2018. The president of the municipal council was elected on 10th November 2020. On 10th November 2020, the election to the post of president was held. I request the court to kindly take judicial notice of this fact that till then, no nominated member has cast his vote in the election of the president. The petitioners herein were nominated on 22/7/2021. They have participated in the meetings of the council, but they have never cast a vote in any meeting of the council so far. The election notice was issued on 22/12/2021. And the vacation commenced on 24th.
What this is what election notice of what?
For the present election, present post of president, which is the subject matter of this writ. That was issued on 22/12/2021. At the last minute on 28/12, they prefer the writ petition before the vacation bench.
We know that interim order was granted, they participated, then they withdrew the petition.
On 29/12, the interim order was granted. I agree. All those facts are already brought to the notice of the court. Election was held on 30/12. But what is not told is the council has 29 elected members. Elected members, 1 MLA, 1 member of the parliament, and if the petitioners had not cast their vote or had not participated, I would have been elected by a majority of 3 votes, having secured 16. I have secured 16 votes at the election. Whereas the 5th respondent secured 14 votes of the persons having right to vote, plus 13 votes, and petitioners, by virtue of the interim order, they participated and cast their vote in favor of her. So the election officer decided to report the matter to the court, saying that this is the
How many nominated members? 29
Four,
elected
four.
members.
Four nominated members. All the petitioners, all the four petitioners.
Yes.
So for the first time, they participated by virtue of the interim order, and the by a majority of 1 vote, 17:16, including 4 petitioners, nominated members. The 5th respondent claims that she is duly elected. And thereafterwards, the matter was heard at length before the learned single judge. And the writ petition ultimately, after the hearing, and the court even expressed its opinion, they withdrew the writ petition on 22/2. On 22/2. However, the interim order granted was a limited interim order to participate in the election meeting of 30/12. That was the limited interim order was made, and with the withdrawal of the writ petition, that interim order came to an end. However, court granted indulgence by continuing the interim order. Kindly appreciate the fact that what was granted was only the right to vote pursuant to the interim order. The order of the court is placed before the court at page 46 of the writ petition. Kindly come to page 46. The learned additional government advocate accepts notice for respondents 1, 2, and 4. She so and so learned senior counsel for the petitioners and the learned additional government advocate are heard on the grant of interim order. The learned senior counsel for the petitioners relies upon a decision of the division bench in WA number so and so, dated 13/12/2021, and submits as in the other case, so in the present case. The question is whether, in the absence of distinction between an elected member and a nominated member in the relevant rules, a nominated member cannot be excluded from casting his or her vote. The learned additional government advocate relies on the constitutional provision under Article 243(2)(a)(14) of the Constitution of India, read with Section 11(b)(1) of the Karnataka Municipalities Act 1964. It is seen that the division bench of this court is, in similarly premised petition, has modified the interim order granted in the writ petition, permitting the nominated members to participate in the election and cast their votes, with a further direction to announce the result of the election, and such declaration shall be subject to final decision. In the light of the question that is canvassed and the interim order granted by the division bench, the petitioners are permitted to cast their votes. Kindly mark it. Permitted to cast their votes in the ensuing elections to be held on 30/12 for the post of president, Malur Town Municipal Council, and the declaration of result of such election shall be subject to further orders. Kindly mark. So it will be subject to the further orders to be made. Here itself, I may clarify that the writ appeal in question did not relate to conduct of any meeting. It was to hold an election to the post of member of the Legislative Council, which is not done at a meeting of the council. This premise on which the interim order has been secured itself was a false premise. Be that as it may, the interim order was made subject to the final result. And kindly permit me to show what is the final result that is made. Now, with a memo, I'm placing that order. I don't think that order was placed before the court. Order permitting withdrawal of the writ petition. What is it? My learned colleague who is present physically before the court will.
Yes, we have got the.
Yeah. Order dated 22/2 may kindly be perused. Para 2 may kindly be perused. Petitioners have filed a memo. Yeah. Page 11 of this. The order commences at page 9. Yeah. Internal page 3 may kindly be perused. Yeah. The petitioners have filed a memo seeking leave of this court to withdraw the writ petition, reserving liberty to file a comprehensive writ petition, challenging the validity of proviso to section 11(1)(b) of the Karnataka Municipalities Act 1964. The memo is placed on record. The writ petition is dismissed as withdrawn, reserving liberty as sought for. The interim order granted on 29/12/2021 is extended for a period of 7 days from today, so as to enable the petitioners to file a comprehensive writ petition as sought for. Liberty is reserved to the fifth respondent to file an application. This is very important. I request the court to kindly mark. So my right is protected there. Liberty is reserved to the fifth respondent to file an application before this court for restitution of his right. So this is how that writ petition came to an end. And I very respectfully submit that the extension of the interim order had no effect because the interim order was only to cast their votes on 30/12. There could not be any extension of the same. Be that as it may, even that interim order's extension expired on 29/2. So it ceases to operate. Now thereafterwards, my application is being actively considered by that court for restitution to the office of the president. So these are the facts in which the present petition has been. I have some preliminary objections to the maintainability of the petition. Firstly, once the writ petition is withdrawn, and with that the interim order merges in the final order, and my right to become the president is protected by an express order for restitution.
What? It is dismissed as withdrawn. So they have been given the liberty to file a fresh writ petition. They have filed it.
They have filed
can't
a fresh.
dismiss it on the ground that they can't file the writ petition.
No.
The effect was withdrawn with the liberty. Liberty was granted.
I'm obliged for that observation. I'm obliged. If I may say so with respect, in identical circumstances where such liberty was given, the Honorable Supreme Court had occasion to consider what will be the effect of dismissal of a writ petition as withdrawn, and what will happen to the interim order that was secured in the interim. That may kindly be perused. Kalabharti Advertising, 2010 9 SEC. I've given a compilation. The first case at page 1.
Speak into the mic so that he can listen.
We have not received any compilation.
we'll see that if it is not already furnished. See, we'll give the list immediately. Yeah. May I request the court to kindly. This was an identical case where a writ petition had been presented by respondents 1 to 5 in this case, and they withdrew. The facts are available at page 4, para 4, page 443. I'll not trouble the court with that. This thing. Kindly come to para 7. Being agreed, some of the members of the society, respondents 1 to 5, filed writ petition number so and so before the Bombay High Court against the society and the appellant for cancellation of the permission granted in favor of the appellant. During the course of hearing of the said writ petition, the Joint Municipal Commissioner, Sri so and so, filed an affidavit to withdraw the earlier order approving the erection and for permission to pass fresh order in accordance with law. The court accepted the said affidavit, permitted the corporation to withdraw its earlier order, with further liberty to pass fresh orders without giving an opportunity of hearing to the appellant or the society, as it had already been done while passing the earlier order. In pursuance of the said order, a fresh order was passed by the respondent corporation on 11/2/2008, not approving the erection of hoarding which had been earlier approved. Hence these appeals. So that is how. So thereafter, those respondents withdrew their writ petitions. So the question was, what was the effect of that withdrawal? Kindly come to para 15, page 446. Page. Running page 10. Yeah. The law declared in such matters, this is how it reads. No litigant can derive any benefit from the mere pendency of a case in a court of law, as the interim order always merges into the final order to be passed in the case. And if the case is ultimately dismissed, the interim order stands nullified automatically. A party cannot be allowed to take any benefit of his own wrongs by getting an interim order and thereafter blame the court. The fact that the case is found ultimately devoid of any merit, or the party withdrew the writ petition, shows that a frivolous writ petition had been filed. The maxim, actus curiae nevinum gravabit, which means that the act of the court shall prejudice no one, becomes applicable in such a case. In such a situation, the court is under an obligation to undo the wrong done to a party by the act of the court. Thus, any undeserved or unfair advantage gained by a party invoking the jurisdiction of the court must be neutralized, as the institution of litigation cannot be permitted to confer any advantage on a party by the delayed action of the court. Then there is a review of the case law. Kindly come to para 24, the conclusion reached therein. Page 448, 12, running page 12. It is not permissible for a party to file a writ petition, obtain certain orders during the pendency of the petition, and withdraw the same without getting proper adjudication of the issue involved therein, and insist that the benefits of the interim orders or consequential orders passed in pursuance of the interim order passed by the writ court would continue. The benefit of the interim relief automatically gets withdrawn or neutralized on withdrawal of the said writ petition. In such a case, concept of restitution becomes applicable. Otherwise, the party would continue to get benefit of the interim order even after losing the case in the court, The court should also pass order expressly neutralizing the effect of all consequential orders passed in pursuance of the interim order passed by the court. Such express directions may be necessary to check the rising trend among the litigants to secure the relief as an interim measure and then avoid adjudication of merits. This is how the court has opined. Then paragraphs 34 and 35. Identical facts. Para 34. The respondents 1 to 5, for reasons best known to them, have prayed for withdrawal of the writ petition number so and so, and the High Court wide order dated so and so allowed the said respondents to withdraw the same. The order reads as under. Quote, as per the statement of Mr. So and so, on 4/2/2008, the earlier order has been withdrawn by the corporation, and fresh order has been passed by the officer concerned. The copy of the said order is produced. It is masked Exhibit X in for identification purpose. She so and so has further reported to the court that the action of removal of the holdings has already been commenced and it will be complied within 2 or 3 days. In view of the fresh order passed by the corporation, marks Exhibit X, the statement of so and so, learned counsel for the petitioner states that the grievance in the petition is redressed, therefore he may be allowed to withdraw the petition. Kindly mark it. Next is very important. With liberty to file a similar type of petition if occasion so arises. The petition is allowed withdrawn with liberty as prayed for. Para 35. Withdrawal means to go away or retire from the field of battle or any contest. Thus, the word withdrawal is indicative of the voluntary and conscious decision of a person. Therefore, if the said writ petitioners, respondents 1 to 5, have voluntarily abandoned their claim withdrawing the said writ petition, they cannot be permitted to take any benefit of the orders passed by the High Court or the statutory authority in pursuance thereof. Once the foundation is moved, the superstructure is bound to fall. Interim relief is granted only in aid of and as ancillary to the main relief, which may be available to the party at the time of final adjudication of the case by the court. In case the orders passed by the High Court and consequently by the corporation are accepted to be in effect even today, it would tantamount to allowing the writ petition without any adjudication on the issues involved therein. Then 36, after obtaining the interim relief, a party cannot avoid final adjudication of the dispute on merit and claim that he would enjoy the fruits of interim relief even after withdrawal or dismissal of the case. Law certainly would not permit such a course. Respondent 1 is a practicing advocate. He is not a layman, nor can it be assumed that he would not understand the consequences of withdrawal of the petition. Therefore, all orders passed by the High Court and the statutory authorities stood washed away on withdrawal of the writ petition, and the said writ petitioners cannot claim any benefit either of this same. So this is the law declared, and therefore my very respectful submission is whatever has happened pursuant to the interim order, it stands nullified, and the Honorable Single Judge has therefore rightly directed restitution, which is being considered. So on this count alone, my very respectful submission is that the writ petition is liable to be dismissed in limine. The added factor is there is no appeal against that order dated 22/2. There is no writ appeal presented against that order, granting restitution to me in the writ petition that was filed by the petitioner's hearing.
We are concerned with the constitutionality of the program. If you file an application, a single bill will be considered, right?
Yes. So since there is no writ appeal, that order has become final. And therefore, my very respectful submission is the writ petition is liable to be dismissed in limine. May I also bring it to the notice of the court that the order permitting withdrawal the withdrawal reserved liberty to file a comprehensive writ petition challenging the validity of the proviso to section 11(1)(b) of the Karnataka Municipalities Act. Whereas in the present writ petition, without any such liberty being reserved, the constitutional validity of the very amendment to the Constitution, 74th Amendment, is under challenge, questioning the validity wires of Article 243R. No doubt, there is not a whisper in the entire writ petition as to why it is bad, be that as it may. No such liberty was reserved. So prayer number 5 at page 24 of the writ petition. Kindly permit me to show from. Page 24. Declare that the proviso to Article 243(R)(2)(a) of the Constitution of India is ultra vires Article 14 of the Constitution of India and contrary to the basic structure of the Constitution. Or read down the proviso to Article 243(R)(2)(a) of the Constitution of India as not applying to elections for the post of President and Vice President of the Municipal Council held under Section 42(2) of the Karnataka Municipalities Act 1964 and the rules framed thereafter. So this prayer could not have been made. It was beyond the liberty reserved, and since the writ petition was dismissed as withdrawn, they could not add any further prayers than what was specifically reserved. So on this count, since the Constitution cannot be questioned and it is not permissible to raise such a prayer, the protection given to Section 11(b) that I will demonstrate in a minute cannot also be challenged, where the nominated members are denied their right to cast vote at the meeting of the council. I request the court to kindly make meetings of the council. Elaborate argument has been advanced as to the concept of meeting. Before I address another preliminary objection is, now all these 4 nominated members, they have cast their vote on 30th. There is no further meeting to take place. Therefore, their prayers in the writ petition at page 23 declare that the petitioners as nominated councillors are entitled to cast their vote in the election of the post of President, Vice President under Section 42(2) of the Municipalities Act. Declare that the votes cast by the petitioners in the election held on 30/12 for the post of President in respondent number 3 council as valid and sustainable. As also prayer number 6, it is in fact a repetition of the earlier prayer. Prayer number 6. declare that the petitioners are entitled to participate and cast their votes in the election to the post of president or town municipal council by virtue of being nominated councillors under the provisions of the Act. These are all prayers which are already, they have become infructuous because election has been held, meeting has been held on 30th, and therefore no further prayer could have been made after the meeting is over. So I therefore very respectfully submit that these prayers are infructuous and the petitioners have no locus to question any further proceedings. The petitioners, they are in no way affected. That a writ petition is not maintainable for academic purposes to question constitutional validity is so well settled right from Charanjit Lal's case. I just cite one paragraph there on locus standi, page 16 of the compilation. Paragraph 7 at running page 20. Charanjit Lal versus Union of India. AR 1951, Supreme Court, page 41. A constitution bench declared that unless a person is directly affected, he cannot question the constitutional validity. Now, this is para 7 at page 20. May kindly be closed. It has been held in a number of cases in the United States of America that no one except those whose rights are directly affected by a law can raise the question of the constitutionality of that law. This principle has been very clearly stated in Hughes versus Justice Hughes in McCabe versus Hutchinson. Quote, it is an elementary principle that in order to justify the granting of this extraordinary relief, the complainant's need of it and the absence of an adequate remedy at law must clearly appear. The complainant cannot succeed because someone else may be hurt. Nor does it make any difference that other persons who may be injured are persons of the same race or occupation. It is the fact clearly established of injury to the complainant, not to others, which justifies judicial interference. Now that the votes have been cast, they have become functus officio. Now the law will take its course and either the fourth respondent or the fifth respondent will get elected. Petitioners are no way affected. Unquote. On this statement of the law, with which I entirely agree, the scope of the discussion on this petition is greatly restricted, at least in regard to the first two fundamental rights. I may clarify here. There it was an individual who validity of a law, which had taken away the administration of a company. And therefore, petitioner's rights were not affected. That is the ultimate finding. And therefore, the court said, without getting personally injured, he is not entitled to maintain a writ petition. Kindly come to the next page. Last sentence in that paragraph. Where Justice Mukherjee has also opined that such shareholders have no locus standi. The only question which has to one sentence. Article 19(1)(f) has been infringed. It would be for the company to come forward to assert or vindicate its own rights, and not for any individual shareholder to do so. In this view, the only question which has to be answered is whether the petitioner has succeeded in showing that there has been an infringement of his rights as a shareholder under Article 31 and 19(1) of the Constitution. This question has been answered by Justice Mukherjee, that I do not wish to add anything. So Justice Mukherjee at paragraph 42 and 44 has reiterated this principle. Justice Das at page para 68 has reiterated, ultimately saying that locus can only be for that person who is directly affected. So in the instant case, my very respectful submission is they have cast their votes. Whether those votes are to be counted or not, it is a matter between the fourth respondent and the fifth respondent, and the petitioners have no locus to come before the court and ask for prayers. So with these preliminary objections, I very respectfully submit. So far as the merits are concerned, firstly, on the question of constitutional validity of the proviso to Article 243(1), by which R2, by which the nominated persons are denied the right to vote at the meetings of the municipality. Whether that offends the basic structure is the short question. Now, so far as the writ petition is concerned, there is absolutely no statement or ground raised as to what forms the basic structure which has been violated, except a laconic statement at para 16.3, page 15. Page 15 of the petition, para 16.3. This is how they attack Article 243. It is submitted that Section 11 of the Municipalities Act 1964 is based on the proviso to Article 243 or 2A of the Constitution of India. In this regard, it is submitted that excluding nominated councillors from voting in the election to the post of President and Vice President of the Municipal Council on the basis of the proviso to Article 243 or 2A of the Constitution of India is violative of Article 14 and contrary to the basic structure of the Constitution of India. As stated supra, the artificial distinction between nominated and elected councillors, which is sought to be made, falls foul of Article 14 of the Constitution. May I request the court to kindly permit me to show from Article 243R what is permitted and what is not permitted. What is permitted is, I kindly take judicial notice of the fact under the Constitution. (243) capital R. Save as provided in class 2. All these seats in a municipality shall be filled by persons chosen by direct election from the territorial constituencies. Kindly mark. So the foundation for a municipal council is direct election from the territorial constituencies in the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. But as an exception to this, next provision, class 2, it provides the legislature of a state may by law provide for the representation in a municipality of persons having special knowledge or experience in municipal administration. So only persons with special knowledge and experience in municipal administration could have been nominated. But even then, kindly come to the proviso of this clause, bottom of it, provided that persons referred to in paragraph 1 shall not have the right to vote in the meetings of the municipality. I request the court to kindly also note another provision. Now the Constitution where act is in the hands of the court. Kindly come to Article 243 ZAC. There cannot be any law contrary to this mandate of the Constitution. There could be a nominated member, but he shall only be a person with special knowledge or experience in municipal administration. And such a person shall not have the right to vote. There cannot be any violation of this principle because Article 243 ZF says all laws in violation of it shall cease to operate after 1 year. ZF. Continuance of existing laws and municipalities. Notwithstanding anything in this part, any provision of any law relating to municipalities in force in a state immediately before the commencement of the Constitution, 74th Amendment Act 1992, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed by a competent legislature or other competent authority, or until the expiration of 1 year from the commencement, whichever is earlier. The other one is about the continuation of the existing municipalities that I will not trouble the court. So there could not have been a law to give voting rights at the meetings. There is a constitutional embargo under 243 ZA. And more importantly, in the instant case, kindly take the act for a minute. Section 11(1)B may kindly be perused. Section 11(1)B. The municipal council shall consist of not more than 5 persons nominated by the government from amongst the residents of the municipal area, and who are, kindly mark this, persons having special knowledge and experience in municipal administration. Kindly pause for a minute. Yes, up to this, it is in accordance with the constitutional mandate. But beyond that, or matters relating to health, town planning, or education, then are social workers. This is not permitted under the Constitution. So all the petitioners are nominated under this provision. Party workers are being nominated under this provision to tilt the majority. Whether it would be permissible. Only men with...
Nobody has questioned their nomination. Anybody, any challenge?
No, I'm not.
In this appeal?
No. I'm not challenging. I'm not challenging. I'm only bringing it to the notice of the court. I'm only bringing it to the notice of the court that 11(1)(b), in so far as it travels beyond 243(r), itself is against the constitutional mandate, let alone violation of the basic feature. Be that as it may, the proviso to this clause at the bottom of the subsection, provided that the persons referred to in clause B shall not have the right to vote in the meetings of the municipal council, is in tune with Article 243(r). So what is the basic structure that is offended by Article 243 or providing for nomination and denial of right to vote to those nominated members? My very respectful submission is, it is a newly added provision. It is for the first time introduced in Constitution. The very concept of nomination is for the first time introduced. Since it is only a nomination, rightly the Constitution denied them the right to vote at meetings because it affects grassroots democracy. If nominated members are given the right to vote to tilt the balance and acquire a majority, contrary to the mandate of the constituency or the municipality. Therefore, very rightly, now that is evident from the statement of objects and reasons for introducing this provision that is placed before the court along with the order of the learned single judge in the memo that is just now filed. Statement of objects and reasons of the 74th Amendment may kindly be posted. Just now it was filed. Kindly come to page 1. The Constitution 74th Amendment Act 1992. Statement of objects and reasons. In many states, local bodies have become weak and ineffective on account of a variety of reasons, including the failure to hold regular elections. Kindly mark it. This will have no application to nomination. Regular elections, prolonged supersession, inadequate devolution of powers and functions. As a result, urban local bodies are not able to perform effectively as vibrant democratic units. Kindly mark. To work as a democratic unit of self-government. Having regard to these inadequacies, it is considered necessary that provisions relating to urban local bodies are incorporated in the Constitution, particularly for, kindly come to clause B2. I will not trouble the court with the other clauses. Ensuring regular conduct of elections. 3. Ensuring timely elections in the case of supersession. And 4. Providing adequate representation for the weaker sections like the scheduled castes, scheduled tribes, and women. So this is the concept that has been introduced. Grassroots democracy, a representative democracy by directly elected members. And incidentally, while doing so, kindly come to the broad criteria for specifying the said areas being provided in front of the etc. etc. Clause B may kindly be seen. 3. Paragraph 3B. Composition of municipalities which will be decided by the legislature of a state having the following features. Persons to be chosen by direct election. 3. Representation of persons having special knowledge or experience of municipal administration in municipalities without voting rights. So the very object of nomination was to get an advisory committee, advisory person who will function as an advisor to the council with his expertise and without the right to vote. Why he is denied the right to vote? That is to protect the grassroots democracy as a self-governing unit. Otherwise, it would be easy for a government to pack the municipal council with nominees who can tilt the balance and get always a favorable president elected for the government of the day. So that was to be prevented, and therefore the amendment came to be introduced. So with these submissions, I request the court to kindly take note of the law declared that the statement of objects and reasons may be read to gather the intention of the legislature. That's too well known. I will not trouble the court with the reading of those judgments. I've given it at grassroots democracy. 2 judgments I have cited. Yeah. That is the year 1961 Supreme Court 1602. And year 1970 Supreme Court 1589. Paragraphs 12 and 11 respectively that I have given the note itself. And most important question for this honorable court to decide is, what is the nature of the right to vote? Is it a fundamental right? The answer is an emphatic no. Court the judgments after judgments of the Honorable Supreme Court have declared that the right
is statutory right. Statutory right.
Right. And if I may say so with respect, now there is a slight elevation of this right as a constitutional right that has been used by Justice P.V. Reddy in PUCL case. But it is what is conferred by the Constitution or the statute alone can be a right that is exercised. If it is not conferred, it cannot be exercised. That is so simple. Those judgments also I have placed at part 4 of the right to vote is not a fundamental right. Kuldeep Nair's case. And the latest may kindly be perused. 2016 volume 2. What is citation? Kuldeep Nair's case. I'll give the citation. Now, the latest would be Rajbala versus State of Haryana, where the right under the 73rd and 74th amendments came up for consideration. There is a reference to Kuldeep Nair's case as well. Kuldeep Nair is a Constitution Bench judgment, 2006, volume 7, page 1. That is considered and reiterated here.
Paragraph. Which paragraph? Now, in Rajbala's case, 2016 2 SCC, page 445, which I have placed it before the court at page 83, turning page 83. Paragraph is not mentioned. Paragraph is mentioned. I'll give the paragraphs. Paragraphs 46 and 97. Jyoti Basu's case was the first one to deal with it. Citation given at inside these paragraphs. Jyoti Basu said it is not a common law right. It is not a fundamental right. It is not even a constitutional right. And what is very important to take note of is, in respect of the municipalities, even 326 is not available. Article 326 is not available. At least Article 326 guarantees a right against discrimination. (325) and 326 may kindly be perused. Constitution of India. Answer. (325). No person to be ineligible for inclusion in or to claim to be included in a special electoral roll on grounds of religion, race, caste, or sex. There shall be one general electoral roll for every territorial constituency for the election of either House of Parliament or to the House of, or either House of Legislature of a state, and no person shall be ineligible for inclusion in any such roll or claim to be included in any special electoral roll
for any such constituency on grounds only of religion, race, caste, sex, or any of them. Likewise, 326 may kindly be perused. Next provision. Elections to the House of the People and to the legislative assemblies of states to be on the basis of adult suffrage. The elections to the House of the People and to the legislative assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed on in that behalf by or under any law made by the appropriate legislature and is not otherwise disqualified under this constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime, or corrupt or illegal practice shall be entitled to be registered as a voter at any such election. So both Article 325 and 326 guarantees are conspicuous by their absence in respect of local bodies. Why I am saying this is, Haryana passed a legislation denying right to vote and right to contest, adding some educational qualifications, saying that if you have more than 2 children, you will not be eligible to contest elections. That law was challenged in Rajbala's case, 2016 2 SCC page 445. So I thought I'll directly refer to that case. The disqualifications for becoming a sarpanch or a member of the panchayat is found at paragraph 49 at page 470, running page 108. 108. Para 49 may kindly be produced. Now, all the disqualifications mentioned for MLAs and MPs.
What he will ensure rate of what? It will not rain. Yes. Because it results in stop.
One of the grounds of disqualification was that he has not passed matriculation examination or its equivalent. Now, the constitutional validity of that was questioned. And while upholding the right to vote itself came to be considered. Kindly come to page 469. 107. Para 45. Para 45. Page 107. The right to vote and right to contest an election to a panchayat are constitutional rights subsequent to the introduction of Part 9 of the Constitution of India both the rights can be regulated, curtailed by the appropriate legislature directly, kindly mark it. Both the rights can be regulated, that is, right to vote and right to contest, can be regulated or curtailed by the appropriate legislature directly. Parliament can indirectly curtail only the right to contest by prescribing disqualifications for membership of the legislature of a state. Para 46, next page. It is a settled principle of law that curtailment of any right, whether such a right emanates from common law, customary law, or the Constitution, can only be done by law made by appropriate legislative body. Under the scheme of our Constitution, the appropriateness of the legislative body is determined on the basis of the nature of the rights sought to be curtailed or relevant, and the competence of the legislative body to deal with the right having regard to the distribution of legislative powers between Parliament and state legislatures. It is also the settled principle of law under our Constitution that every law made by any legislative body must be consistent with the provisions of the Constitution. So, saying that the law was tested and it has been upheld. And this is the judgment of the first judge, Justice Charmeshwar. This has been concurred with by Justice A.M. Sapre. There are 97. Maybe there are 97. We will see. (131), running page 131. Paragraphs 94 to 97, discussion. Finding is 97, conclusion is: in the light of the aforementioned two authoritative pronouncements in People's Union Civil Liberties and Javed cases, we are of the considered opinion that both the rights, namely right to vote and right to contest, are constitutional rights of citizen. So kindly mark it, right to vote cannot be a fundamental right, much less can it be basic feature of a constitution. Nagaraj. 2008, volume 6, SCC, page 1. As to what is a basic feature is also the subject matter of several decisions. One constitution bench, only one paragraph I'll cite. M. Nagaraja's case. No, 2006, volume 18 says.
M. Nagaraj.
M. Nagaraj versus that the court will get the 2006-8 SCC page 212, running page 309.
09, running page 309.
Kindly come to para 28 at page. Any page? After a review of the entire case law as to what is this thing, kindly mark paragraph 28. That will be at page 341, running page 341. Yeah. I think Mr. Justice Shetty didn't. Hey, there it is. Yeah. To conclude, the theory of basic structure is based on the concept of constitutional identity. The basic structure jurisprudence is a preoccupation with constitutional identity. In Keshwanand Bharati versus State of Kerala, it's been observed that one cannot legally use the constitution to destroy itself. It is further observed the personality of the constitution must remain unchanged. Therefore, this court in Keshwananda, while propounding the theory of basic structure, has relied upon the doctrine of constitutional identity. The word amendment, kindly mark it, this is very crucial. The word amendment postulates that the old constitution survives without loss of its identity, despite the change, and it continues even though it has been subjected to alteration. This is the constant theme of the opinions of the majority decision in Keshwananda. To destroy its identity is to abrogate the basic structure of the constitution. This is the principle of constitutional sovereignty. Secularism in India has acted as a balance between socio-economic reforms, which limit religious opinions and communal development. The main object behind the theory of the constitutional identity is continuity, and within that continuity of identity, changes are admissible. Can you mark this? This is changes are admissible depending on the situation and circumstances of the day. So, with this, on this touchstone, I request the court to kindly examine the plea of the petitioner. What basic structure is destroyed by this amendment? They are creatures of this new provision. They come in a package. They come without wings or the right to vote. That's a congenital problem because they are not elected. And they are opening their mouth too wide to claim that they also have the right to vote. And if they are denied, it offends the basic feature of the Constitution. With great respect, that issue does not even arise because there is no basic structure violated, much less is it pleaded. And their comparison with the elected members is only impermissible because they are not elected people. Elected members, they come with a mandate of the constituency. These are nominees who don't have a mandate of the local governing unit. So with these submissions, I very respectfully submit that the constitutional amendment, much less the provision which has implemented the constitutional mandate, denying them the right to vote, can be challenged before this argument. And the kindly mark it, the burden of proof is on the petitioners. Charanjit Lal itself made this expressly. Because every constitutional amendment, as also the Act, enjoys a presumption in favor of constitutionality. that AIR 1951 Supreme Court 318. I have given the citation also. Part 5, presumption of constitutional validity. Para 19 at page 143. And 2004 2 SCC page 476 para 42. 2004 volume 2 SCC page 476 para 42. In 2008 2 SCC page 254. There are 19 and 20. I've given the list and the paragraphs. 2008 4 SCC page 720 para 15. Before I conclude, I'll just trouble the court with one judgment. One of the earliest judgments, Balsara's case. Court is very familiar with it. Kindly permit me to read one paragraph.
You are relying on last date. We remember you had referred to a division bench decision of this court saying that 243R has been upheld, something like that.
I'm obliged for that. It is not a division bench judgment. It is a single judge order. I'll give it. Yeah. I'm grateful to the court. Yes. Now, may I refer to Balsara for a minute at page 143. The law on constitutional validity is so succinctly set out. Kindly come to page 158, running page 158. Para 19. May I read it? I now come to section 39 of the Act, which has been impugned on the ground that it offends against Article 14 of the Constitution, which states that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The meaning and scope of this article has been fully discussed in the case of Charanjit Lal, 1950 Supreme Court. Supreme Court reports 869, and the principles laid down in that case may be summarized as follows. 1. Presumption is always in favor of the constitutionality of an act, since it must be assumed that the legislature understands and correctly appreciates the needs of its own people, that its laws are directed to problems made manifest by experience, and its discriminations are based on adequate grounds. The presumption may be rebutted in certain cases by showing that on the face of the statute, there is no classification at all and no difference peculiar to any individual or class, and not applicable to any individual or class, and yet the law hits only a particular individual or class. 3. The principle of equality does not mean that every law must be have universal application for all persons who are not by nature, attainment, and circumstances. Kindly mark it. This is very important. By nature, attainment, or circumstances in the same position, and the varying needs of different classes of persons often require separate treatment. Here, kindly mark it. Elected representatives and nominated representatives. There is a congenital difference between the two. 4. The principle does not take away from the state the power of classifying persons for legitimate persons. 5. Every classification is in some degree likely to produce some inequality, and mere production of inequality is not enough. 6. If a law deals equally with members of a well-defined class, it is not obnoxious and it is not open to change or not open to the charge of denial of equal protection on the ground that it has no application to other persons. 7. While reasonable classification is permissible, such classification must be based on some real and substantial distinction, bearing a reasonable and must relation to the object sought to be attained. The classification cannot be made arbitrarily and without any substantial basis. Then they go on to say that, but this is the law. It has been uniformly applied and the law stands the test of time. It has been followed by any number of judgments. And the Honorable Court was pleased to ask me which is the judgment by which the constitutional validity of this provision was gone into. Before that, may I also point out that on merits, there is a direct decision of the Honorable Supreme Court holding that nominated members do not have the right to vote. Exactly. Yes. Two 2004 5 SCC, page 409. Yeah, page 253. Page 253. Paragraphs 11 to 13 may kindly be perused. Then, of course, it was a case of no confidence motion against the president. The converse is directly applicable here. If they have no power to remove, they have no power to appoint also. Para 11 at page 266 266. In the present case on facts, we are concerned with post 1994 position. Article 243R brought about a drastic change in the matter of composition of municipalities. It lays down guidelines with regard to the constitution, composition, election, and rights of members of a municipality. Under the Act, members of a municipality are persons chosen by direct election by the residents of a municipal area or ward. Article 243R2A1 allows the legislature of a state to appoint any person as a member of the board who has special knowledge in the field of municipal administration. However, the proviso appended to the said article precludes persons nominated under subclass 1 from having a right to vote in the meetings of the municipality. The Constitution, therefore, kindly mark this, therefore, makes a distinction between elected members and nominated members who play essentially an advisory role. Pursuant to the 74th Constitutional Amendment Act, sections 9, 65, 72 of the Act were amended. Prior to the amendment, the co-opted members were at par with the elected members. However, after 1994, only elected members and members of the Legislative Assembly have a right to vote under section 9(1) of the Act. Under subsection 2 of section 65, as amended, the chairman has to be elected by elected members of the board. This change is very important. Prior to 1994, chairman was to be elected by the members of the board, which is the phrase used in unamended section 65(2). as the co-opted members had a right to vote. However, in 1994, Section 65(2) of the Act was amended. Expression members of the board in the bold section is substituted by the expression elected members of the board. In fact, the expression, the rest of it may be skipped. Kindly come to para 12. In case of Knowles versus Zoological Society, it has been held by the court that the expression majority of fellows entitled to vote in the bylaws of a society would mean the majority of those present at a meeting and entitled to vote, not majority of all electorate, whether present or not. Before us, as stated above, it was that the respondent is claiming causa omniscience in support of his argument that the words whole number of members must be construed as whole number of elected members. We do not find any merit in this argument. In the case of state of Karnataka, it has been observed by this court that although the court cannot supply causa omniscience, it is usually equally clear that it should not interpret a statute so as to create a causa omniscience when there is really none. To sum up, and under pre-1994 and post-1994 provisions, the legislature intended that the chairman and vice chairman shall be removed on passing of no confidence motion by the requisite majority of members having the right to vote. So this is the conclusion. Only those who have the right to vote can participate. Same is the decision by a division bench of our court. Kindly come to the next judgment. ILR 2003, page 274. ILR 2003, Karnataka 4653. Two paragraphs. Paragraph 11, 12.
Yeah.
11 and 16 may kindly be checked. That would come to page 280, running page 280, para 11. The para page 280. Yeah. The above said provisions of the Act with which we are concerned in the present case regarding requisite majority and as to whether total number of members of the council should be considered for reckoning such majority has been specifically referred to a division bench of this court in view of the conflicting decisions by a learned single judge of this court and the division bench in so and so. After considering the relevant provisions with which we are concerned in the present case, in the division bench held that councillor in section 2(6) and section 42(9) of the Act means legally elected members and overruled the decision of in Shivshankar versus Davangere municipality and answered referred questions as follows. Quote, in conclusion, answering the reference, we hold that in order to quantify the 2/3 of the total number of councillors, it is only the councillors who are eligible and entitled for voting, which has to be considered. And as the nominated members under section 11(1)(b) of the Act have no right to vote, their number has to be excluded. And the 2/3 of the members for the purpose of no confidence motion is to be from out of total number of councillors present at the meeting, not general number. Then at para 16, the conclusion is there it was a case where no notice was issued. There is no merit in the contentions of the learned counsel for the appellant. that non-issuance of notice to MP and MPL and their absence in the meeting has vitiated proceedings. It's also the contention of the learned counsel. The term councillors has been defined under 2(6) as any person who is legally a member of the council. In view of the decision of the division bench of this court, in Chandubi's case, it still holds the field. It is clear that for the purpose of section 42(9) of the Act, that is no confidence motion, in order to qualify the total number of councillors, it is only councillors who are eligible and entitled for voting whose number has to be considered, and the term councillor referred to in section 2(6) would mean only legally elected member and not otherwise. And further, the petitioner appellant has not substantiated the contention, etc., that we need. The same thing is reiterated at the bottom of the paragraph with the facts of that case. So the same thing holds good for purposes of our case also. Only elected members are entitled. Then the case where the constitutional validity of Article 243R was considered. This is Chavan's statement. No, Karnataka. Single judge order. No. I'll give the citation in a minute. I'll just pass it up. Savitri. Where are you?
KLJ
2016 volume 2 KLJ.
2003 volume 6 Karnataka Journal, page 286. Page 286.
286. 286.
There it was questioned, but even MPs and MLAs should not be allowed to vote. There are 16 the
KLJ page 3. 2016 volume 2 KLJ page 3, right, Mr.
No, 2003 volume 6. 2003 volume 6 KLJ page 286. Oh, sorry. I'm sorry. Sorry. What I have just now read out is 2015.
Okay, that's what you are referring to is yes. 2016 volume 2. 2003 Justice Chauhan was not here.
No, not 2000. Sorry, I'm sorry.
You are referring to Justice Chauhan's judgment, right?
Yeah, yes, Justice Chauhan's judgment, 2015 or 16?
2016. 16
I argued the case. I defended the provision.
2016 volume 2, Mr. 16 volume 2 KLJ page 3.
Justice Chauhan, as he then was, sitting
2016 volume 2.
Yes. Before the court gets that, may I just point out one provision in the Municipalities Act.
What is it, madam? Island. ILR 2015 Karnataka. 5872. All right, Mister, we'll continue on Monday.
No, I'll conclude in a minute. If,
That's all right.
if no, of course, after citing that judgment, I have to make. I will continue on Monday.
Huh? Monday.
Before that, may I just point out one provision in the Act as to what is the concept of meeting. Meeting is a well-defined concept. Kindly permit me to show the Act itself deals with all kinds of meetings. Section 47 may kindly be perused. Because the proviso denies right to vote at a meeting. A distinction is sought to be made that under the election rules, it is not a meeting. I'll show that also. Kindly see section 47. The municipal council shall ordinarily hold at least one meeting in every month for the transaction of business, which shall be called an ordinary general meeting. 2. The president may, whenever he thinks fit, and shall, upon the written request of not less than 1/3 of the whole number of councillors, and for a date not more than 15 days after the presentation of such request, call a special general meeting. If the president fails to call a special general meeting as provided in subsection 2, the vice president or 1/3 of the whole members councillors may call such meeting for a day not more than 30 days after the presentation of such request, and require the chief officer or the municipal commissioner to give notice to the councillor and give such action as may be necessary to convene the meeting. So any meeting may be adjourned until the next or any subsequent date, and an adjourned meeting may be further adjourned in the like manner. So this is what it is: either a special general meeting or an ordinary general meeting. There is nothing like an election meeting. Now, under the rules also, kindly take the election of president rules. It speaks of a meeting because meeting is where he is denied the right to vote. Kindly come to rule 3. Rule 3 may kindly be closed.
Yes. Go ahead.
Yeah, rule 3. Appointment of a date of meeting. The election of president and vice president shall be held in the meeting fixed by the election officer, and he shall thereupon send to every councillor notice of date so fixed, not less than 7 days prior to the meeting. So it is at a meeting that an election will have to be held. Then filing of nominations, not less than 2 hours before the time fixed for the meeting for the election of president and vice president. Any councillor may nominate any other elected councillor for being elected as president or vice president, as the case may be, by delivering to the election officer a nomination paper completed in form 1. Then kindly come to rule 6. scrutiny of nomination. After the commencement of the meeting, that is, after the commencement of the meeting to hold elections, the election officer shall scrutinize all the nomination papers, etc., etc. Then again, under Rule 8, kindly see sub-rule 4. Any member present at the meeting may refrain from voting if he so chooses to do. Clause 7. The election officer shall cause a record of the minutes of the meeting, which shall contain the names of all the councillors present, and in the case of a division, the manner of their voting, including abstentions, etc. The explanation also refers to meeting. For the purpose of this rule, councillor present means councillor present at the meeting and whose names have been recorded before declaring a councillor duly elected under Rule 8 or before commencement of the meeting, after withdrawal of candidature under sub-rule 4 Rule 7, as the case may be. So it is only at a meeting that an election takes place. And there is a prohibition, total prohibition on the right to cast a vote at all meetings. That would respectfully, I submit that it would include right to elect a president to a municipality. And this was only a by-election. In the main election which was held, no nominated member cast his vote. Yes. With these submissions, I conclude, except placing that judgment, I'll place it.
We have got it. Which paragraph? We have got this Karnataka Law Journal citation.
Yeah, I'll give the exact paragraph. Please.
Yes. Okay. Yes, Mr. You have actually argued.
Yeah, I conclude.
No. What about the probably he may not have heard.
I don't know what's up. Sorry, I did.
Submission. Please speak into the mic so that.
Mr. Mahendra Kumar Lord, here, and this, though it was brought to his lordship's notice that the honorable division bench is at the fag end of the hearing, they pressed for hearing, and then the learned judge started hearing the matter, and he has started dictating an order also.
No. Is it so, Mr.? We are hearing, we have heard you practically. It's for his submissions on Monday or Tuesday.
Yes. I have concluded.
No, but what is happening? The learned single judge is dictating the order.
One second, I'll take the instructions.
Tuesday to pronounce the order. It's supposed to be listed on Tuesday.
The matter is listed on Tuesday for pronouncement of the order.
Announcement
on Tuesday. No order is pronounced so far. Sorry, I did not appear before the government.
All right. We'll take it up on 18th.
Please.
Okay. We will 19th it will come up. Let's see on 18th.
No, that order is not under appeal. Great respect. That order is not under appeal. So it is not open for the petitioner to complain.
Ravi Verma Kumar, Learned Senior Counsel for Respondent number 6, concluded his submission. However, on account of positive time submissions of Learned Senior Counsel for the rejoinder submissions could not be heard. List for further hearing on 18th April 2020.
I have two submissions to make.
What submission?
Monday you make no. You are in a hurry. You wanted to argue even before Mr. We want you to be here, right, Mr. Kumar? Huh? No, we will hear you on 18th. Huh? Yes. 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 Oh. Huh? 58. Yes. Oh. We said no argument. What is to be done?
What is the instruction?
Your client is a professor, right? In Kalburgi. In Kalburgi. Your client is a professor, no? Kalburgi. Yes. Correct. Send to Lordship. Fine. We'll pass the hours. 58. The order sheet, madam, right? Parties along with their counsel present. Case is reserved for, should be reserved, no, reserved for delivery of the, no, all right, don't write anything. That's
56, CR Gopal, Evanna Bellari.
will be, which case? Yes. This is 2012 matter, Mr. It should come.
We are ready to go with the husband, my lord. 2 appeals also.
10 years have already passed. If we get time.
10 years.
Let it come, no. Let it. Why should you call the case at 4:40 and trouble us? It can't be concluded in 4 minutes. They will argue. Next week. We want it.
We are ready to go to husband like our children also. We are restriction to see our children also. It is the main problem. We are ready. I am ready to go with the
next week. Next week.
Next week we'll see.
Monday. Remaining cases 56, 57. Monday. Down. 19. 20th April. 56 list on 20th April. Remaining cases next. One month. Or 59 also is there. I don't recall. Achha.
7,
Let it come on Monday or next week, whatever. 2012. 20th or 19th April. 19th April. 57, 19th April. Okay. You want us to get up, right?
So 57, 19th April.